Incremental settings.
Hey, man.
How are you?
Gotcha. We got
I got it unmuted.
That's your case.
It is, Judge. Is he on?
He's on, I think you may have to put it on gallery to be able to see him there. There it is.
So, Judge, he still has pending charges. He's here on a VOP. He still has pending charges. I believe they're set in April. Is that right, Mr. Patterson?
You'll have to, there you go.
Yes, sir.
So if we could just get a May date, do you expect those to be resolved in April, Mr. Patterson?
Yes, sir.
Okay, well, will you get those resolved and then we'll come back in May?
Okay.
All right, what day in May? May 26th. All right, case is reset for May 26th of 2026. Thank you, Mr. Patterson. All right, at the jail, are we ready for some inmates there? Cheatham County Jail.
Yes, Your Honor.
Go ahead and bring out your first one.
Yep.
It's Fulton for report for, he's in report for tomorrow, I think. All right.
This is Marquise Collins, docket number 19303, page 1.
All right, this is for a hearing on a violation of community corrections. Ms. Libby Watson is the attorney.
She's been in email communication with me, but I haven't seen her yet this morning. State's ready for it.
Mr. Collins, your lawyer is not yet here, so we're going to put your case on the second call and come back to you when your lawyer arrives. Thank you.
Is it to the second?
Yeah, second call. Yep.
Would be today.
You got it tomorrow?
You guys have to go. All right, you're not.
Meeting?
This is Joel Dickerson, Your Honor, docket number 19111.
Mr. Dickerson, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
No, sir. I think I just soon go ahead and take care of it on it.
The affidavit of violation of probation says that you were placed on probation on or about the 10th day of November 2022 for the offense of possession of a firearm with prior violence, deadly weapon conviction, and sentenced to 4 years in the Tennessee Department of Corrections. That was suspended to probation. It is alleged that you have violated your probation by violation of Rule 5, which states that on or about October the 31st of 2024, the officer conducted unsuccessful home visit at 6330 Clarksville Pike, Joelton, Tennessee at 12:33 p.m. The resident stated the offender does not live there and whereabouts were unknown. It's also alleged that you are in violation of Rule 6, that you have not reported to your probation officer since August of 2024, and you understand what you're charged with, is that correct?
Yes, sir.
I want you to understand that if you're found guilty of this, then your probation can be violated and your probation can be revoked, and you can be remanded to serve the sentence of 4 years in prison. Do you understand that?
I do. I'm sorry. I would like a lawyer if that's possible.
You want to go ahead and have an attorney now?
Yes, sir.
All right. Mr. Vaughn with the Public Defender's Office is here. I'm going to appoint his office to represent you and handing him a copy of that affidavit. All right. Not guilty plea is entered. Do you want to set it for April or May?
April. There's no pending charges put in April.
April 28th. All right, your lawyer will be up to talk with you and get you ready for that hearing on April 28th. Thank you.
Thanks, sir.
You ready for James? All right, come on, James.
This is James.
What is your name, please?
James Du Bois, docket number 18905.
Mr. Dubois, you are here today, on a charge of violation of probation. You represent him.
Yes, sir, I do. Mr. Dubois has a multiple count indictment pending out of Dixon County. I believe, are your motions to suppress in April or May, JT?
May.
May, so if we could just get maybe a July date.
May 28th. Was that May 26th?
It's May 13th.
All right, May 26th.
Okay.
I'm tracking it over there, JT.
All right.
Can you go back to this one? Frank? This is so good.
This is Jonathan Krantz, Your Honor, docket number 19710 and 19713.
Judge, Mr. Krantz is my client. That is going to be for plea if you want to bring him up.
All right, we're gonna have Mr. Krantz brought over, from the jail. We'll bring you over in just a little bit. Thank you.
Are you standing in the hallway, Palmer?
Well,
Or Netherlands? I don't know.
this is Jimmy Netherton, Your Honor, docket number 19543.
All right, Ms. Margaret Brady Wilkerson is the attorney. She's a juvenile court. All right, we will have to bring you back, on the second call. Your lawyer's in another courtroom right now. We'll come back to you. Thank you.
Right. No second. Second call.
Thank you, Palmer. Is that the same for Mr. Grant? Go ahead.
Krantz will be brought up. Palmer. He's second call.
Parker.
Morning.
He's got, he's taken upstairs. You need him upstairs now, buddy.
This is Ricky Palmer, docket number 19738.
I was told, he was supposed to be transported to Davidson County, but you want him to transport you to Davidson County too? All right, I'm sorry, at the jail, what is your name?
This is Ricky Palmer, docket number 19738.
All right, Mr. Palmer, you're here to be arraigned on a charge of violation of probation, both an original and an amended violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender is here, will be appointed to represent you, and I'm handing them a copy of both the original and the amended violation of probation.
Waive reading in there, please not guilty.
Plea not guilty is entered. You want to set it for April 28th. Your lawyer will be up to talk with you and get you ready for a hearing on April the 28th. Thank you.
You can go back. Okay, King. King, go back to Parker.
This is Jerry Parker, docket number 18767.
All right, Mr. Parker, you're here to be arraigned on the charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir, I do have a lawyer that represents me.
Margaret Brady is your lawyer? Okay, I see that now. We'll have to, Ms. Margaret Brady Wilkinson is not here. She's in another court at the moment. We'll put you on the second call to have you come brought back when she is available. Thank you.
Yes, sir.
She has heard of big court, little court. Apparently it doesn't take.
This is Trace Perry, docket number 19849.
Judge, I represent Mr. Perry. That is going to be for plea as well, if he can just be brought up.
All right, Mr. Perry, because your case is going to involve an entry of a plea, we're going to have you brought over from the jail here into the courtroom, and we'll take care of you then. We'll bring
Yes,
you over
sir.
just a little bit. Thank you.
That it? Hard to understand.
We're going to bring you over for an entry of a plea in the courtroom, okay?
Yes, sir. Am I good? Hard to understand.
So, Jerry's workers, call her, this guy right here, continue.
Stephen from the hall, we have one compared. This is Patrick Peters, docket number 19294.
Mr. Peters, you're here today to be arraigned on a charge of probation violation. You have the right to an attorney. Do you want a lawyer to represent you?
Yes, sir, but could I ask a question?
Well, I'm going to appoint the public defender to represent you. Now, the questions that you may have may be better answered by your lawyer rather than you making a statement in open court. Do you understand that?
Yes, sir. I'd still like to make a statement if that's all right.
You what?
Yes, sir.
All right, you got a question?
Yes, sir. I was wondering and hoping if I could maybe get a bond. My wife is struggling with her finances currently out there, and I was hoping maybe I could get a bond on this.
I'm going to, number one, you will have to talk with your lawyer who will then need to file a motion for a bond. Because if there was a violation of probation warrant issued, it means that you've already had the opportunity to be on probation and it's alleged that you violated it. So there was a hold for a hearing. So I've appointed you a lawyer. You need to talk with your lawyer and discuss with him the possibility of getting a bond set, okay?
Yes, sir.
All right, thank you.
What is that?
All right, May 26th.
Okay, the third week go down, no, nobody's going yet, okay, so you go back. So I go back for.
We'll sit down and movie and real calls with the speaker.
Yeah, you go back, they ready for you again. Benjamin Richardson, docket number 19858-59.
You represent Mr. Richardson.
Good morning, Your Honor.
All right, good morning. Mr. Richardson, you're here to be arraigned on a charge, on an indictment charging you with aggravated burglary of a habitation, domestic assault, DUI second offense, and public intoxication and possession of a handgun. While under the influence, you have the right to an attorney. Do you wish to have a lawyer appointed to represent you?
Yes, Your Honor.
All right. We have two separate indictments. You have another violation of a no contact order indictment. I'm going to hand both of those to the public defender who is here in the courtroom, and I've appointed them to represent you.
We'll waive a formal reading, judge, enter plea not guilty.
A plea of not guilty is entered. Date for a setting of this.
This should be
This is
on,
General Stephen.
well,
This is
and
yours.
I think, when do
Is
you
it
want?
to you? All hers.
Now we have a motion to revoke on Mr. Richardson.
There's a motion to revoke Mr. Richardson's bond.
Yes.
He looks pretty revoked to me.
Well, he could make it again
Okay.
because he's there on the capias because he didn't show up for court.
Okay.
We have someone coming from the scram today.
So is that set for today?
Yes, Your Honor.
This is the first I've heard about any of this.
Okay. Well, we're going
That's
to,
because you just got a.
we'll leave it on the docket for today, and then we'll determine whether or not it's able to be heard today. But clearly he has a violation or a failure to appear that resulted in a conditional forfeiture of his prior bond, so we'll see where we are. So you want to have him brought over so you can talk to him?
Yes, please.
All right, we're going to bring Mr. Richardson over then with the other inmates so that Mr. Vaughn can talk with him about this situation on his bond.
Thank you, Your Honor.
All right, thank you. You'll be brought over so your lawyer can talk with you.
Thank you, Your Honor.
Robinson.
This is Damian Robertson, docket number 19619.
All right, Mr. Robertson, you are here today, charged with violation of probation. Mr. Vaughn, you represent this individual?
Who is this, Judge?
Damon Robertson.
Yes, Judge, he is going to admit that he's in violation and be reinstated, with the hook of he must be in a rehab within 45 days and notify myself and the court when that is done.
You want to do this by Zoom then?
If he's fine with it.
Mr. Robertson, we're going to take care of your case and we can do it by Zoom if you're agreeable to that. Can you hear me well enough to do this?
Yes, sir.
All right. Mr. Robertson, raise your right hand. Let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. I'm going to ask you to put your hand down and speak loudly when you answer this so that we can make sure our court reporter here in the courtroom can hear everything. State your full name for the record.
Damon Maurice Robertson.
Mr. Robertson, you are here today charged with probation violation. I need to make sure you understand your rights. Do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
Do you understand that you would have the right to have a lawyer and to have one appointed if you cannot afford your own? And we have done that with the public defender. Do you understand that?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to a hearing in this case and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon, which essentially is that you will be reinstated on time served to probation with a condition that you will be required within 45 days to enroll in an inpatient treatment facility.
I have one that I'll be in within 48 hours.
All right, well, then you won't have a problem with doing it within 45 days, but that's, you understand they're giving you 45 days. If you can do it in 48 hours, that's great. But you understand that?
Yes, sir.
All right, you understand everything I've explained to you?
Yes, sir, I do.
Do you want to plead guilty to the charge of probation violation and waive your right to a hearing and to an appeal?
Yes, sir.
Then upon your plea of guilty, I find you guilty, order that you be revoked to serve your sentence. But by agreement with the state and your lawyer and on time served that you've already served, we will reinstate you to probation. And there will be an additional condition that within 45 days, you must enroll in an inpatient treatment facility. That 48 hours will take care of that, okay?
Yes, sir, I will have it. Yes, I already been talking to places. I will have the information sent today. I mean,
Good luck to you with your treatment. I hope that you give it the best effort, okay?
Yes, sir. Thank you, sir.
All right, good luck to you. Thank you.
He can go back.
I saw her from the work.
Okay. I don't know, that'll turn it.
Keisha Short, docket number 19583.
Mr. Vaughn, you represent this defendant?
Yes, sir, I do. Judge Ms. Short is here on a violation of probation. She's going to admit that she is in violation and be reinstated back onto probation.
All right, reinstate on time served.
Yes, sir.
Ms. Short,
Yes, sir.
I'm going to allow you to enter this plea today, and we're going to do it by Zoom to expedite things. Is that all right with you?
Yes, sir.
All right, then I need you to speak loudly when we go through this. but that's because my court reporter here in the courtroom has got to hear everything you're saying. Would you raise your right hand and let me place you under oath? Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, officer, is there a way to turn the volume up on that device that they're listening to? Apparently, they're having a hard time hearing us. Is that better for you? Can you hear me? I'm just wanting to make sure you can hear everything I'm saying.
Yeah, I got the speaker right here.
All right.
Okay.
Do you understand that you were charged with probation violation, and do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes, sir. I'm sorry, I'm holding the speaker up. I hear you though.
Okay.
It sounds like.
You ever see that scene where in the first season of Saturday Night Live where they're doing the weekend update and Chevy Chase says, now to help us recap the news, we're going to have Garrett Morris, who's from the school from the Hard of Hearing. And what he does is he says, they repeat it, and all he does is just shout it as loud as he can. That's kind of what I feel like I'm doing right here. So, all right, let's start again. Can you hear me any better?
Okay, I can hear you. Yes, sir.
All right, because I'm not sure I can keep shouting as loud as I was, or at least talking as loud as I was. All right, do you understand you have a right to plead not guilty and to have a hearing?
Yes, sir.
Do you understand you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, sir.
You understand that if you had that hearing and I found you guilty, you could appeal whatever I did to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
He can't give you legal advice. Your lawyer's here in the courtroom. It's my understanding that you want to plead guilty to this charge with the agreement that you be reinstated on time served to probation today.
Yes, yes, sir.
All right. Do you understand that if you wanted to contest this violation of probation and we had a hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals if you didn't like what I did? You understand that?
Yes, sir.
Right. Do you want to plead guilty according to this agreement and waive your right to that hearing?
Yes.
Your
Yes,
lawyer is
sir.
nodding yes.
Yes, sir.
Right.
I'm sorry.
That's all right. It's a little bit of an awkward situation.
Yes.
But upon your plea of guilty, I find you guilty of violating your probation order that you be revoked to serve your sentence, but on time served and by agreement with the state, I'm going to reinstate you to probation today. Now, this is a one-time deal, so if you violate your probation again, you're going to have to serve your sentence.
No,
So
it
make
won't
sure-
happen again.
All right.
Oh,
Well,
no.
make sure you stay out of trouble, okay?
Yes, sir.
Thank you, Ms. Short.
Thank you, Mr. Vine.
So stand right there, but you go, and stand, he's ready. All right. Yeah, I'll go on. So,
You can go back. This is Sandra Winstead, docket number 19273.
All right, Ms. Winstead, you're represented by the public defender, Mr. Vaughn.
Yes, Judge, she's here on a violation of probation as well. She is also going to admit that she's in violation, and then she'll be reinstated, but she will be transferred to community corrections.
All right, Ms. Winstead, can you hear me okay?
I'm sorry, I didn't hear you.
Might as well bring her up.
We're just going to have you brought over. We're going to bring you
Okay.
over to dispose of your case.
Okay.
All right, thank you. It is on. Got the last one we got?
Yes, Your Honor.
All right, thank you. All right, we'll go through the regular docket then. 2025-019-793, State versus Cheryl Doherty. Mr. Lockett, Andrew Lockett. Good morning.
We've got an agreement on this case, and I've got the TBI diversion form back. Only issue, this is going to be an out-of-state probation. So I've spoken with our probation officers, and they've asked if we get into this plea sometime in excess of a week so we can finish getting some of this paperwork together.
Okay, well, this is my last day in Cheatham County, so you would have to move you to the next, any opposition from the state about moving it? What is your next criminal date? Who is the judge? April 14th in front of Judge Wallace.
Thank you, Judge.
All right. Twenty 25-019-683, State versus Terralanda Spritz.
You want to make this, that's my case. Hopefully we'll have a resolution for that today.
I'm sorry, repeat that.
Hopefully we'll have a resolution for that. Sorry.
That's all right.
Hopefully we'll have a resolution for that case today.
So you'll put it on a second call
Yes,
to see if
please.
you can work it out. All right.
Yes, thank you,
That's
Judge.
fine. Thank you.
I do remember that skip.
That's all right. And Austin Lee Howard, Mr. Flanagan, they say was transported to Davidson County.
Yes.
And-
They don't call me, they just take that.
You have that hearing, you have the sentencing hearing or the plea at 1:30 today, is that right? All right, 1, I guess it is at 1. So.
I'll have to leave at 2 to go to my physical therapy, the Palace of Pain, but my co-counsel will be here.
Right.
So we need a new date on,
Mr. Howard,
I almost want to put it on April 7th, which is his Metro day, but I won't do that.
well, what did you say? April 14th.
Yes.
I skipped over Michael Deshaun Holt.
I think he's in custody in Montgomery County. Oh, he's here? Never mind.
And we have a motion to revoke his bond
I
for
do.
failure to appear. Does he have a lawyer?
No, not here. No, he doesn't. He has not been formally arraigned here. I
Right.
found that on his.
So if we have him in custody, we need to bring him up and arraign him, and then we can deal with whatever the bond situation. I'm gonna put him on the second call as well. We'll need, if we need Mr. Michael Deshaun Holt, they tell me he's in custody here. We need to have him brought up with the other inmates. 2025-019-749, State versus Milton Kirk Hunt. Mr. Vandervoort, or Mr.
I'm Mr. Vanderbilt today, Your Honor.
A better looking younger version of Mr. Vandervoort. Huh? All right, Mr. Mills, what do we have? We have a final plea day here.
The state's gonna make a motion to nollie.
State is nolling the case.
Yes, Your Honor.
All right, case is dismissed on the motion of the state. Thank you.
Thank you, Your Honor.
2025-019-744, State versus Messiah, Israel.
Yes, sir.
Sylvie,
We need some motion dates on that, please, sir. And I'd also like some clarification. I had filed some motions prior to this trial. Would you like for me to refile those to address
I
them as
don't
well?
see a need to refile them. This is, as I've stated, my last day in Cheatham County for this term of court, so we'd be looking at July for the motions. And
Yeah, because we have some fundamental motions to file in that matter.
what about July the 8th?
Does that work with your schedule?
It does.
General Sylvie, we're talking about Mr. Israel's case. They have motions they want to file. I was suggesting that we set the 8th of July as a motion day for any of the cases, both this case and any other case that I have motions. We'll set it for July the 8th. All right, and that's agreeable with everybody involved?
Yes, sir. Thank you, Your Honor.
Well. Yes.
We'll do motions on both cases.
Yes. Anything you want to file, I'll hear on that day.
Judge, I have an announcement on one.
All right.
Page 3, Braxton Milam. Come up, Mr. Milam. Well, where did you go? You talked to him about this? No. I don't know where the DA went, but it's going to be dismissed on payment of restitution, and he has paid the restitution.
He
And
has or has not?
he has, let me back up a little bit,
Kind of paid?
paid it. He grew up in Kingston Springs with my wife and all her friends. He paid the $2,500 to my wife. So she may be going to a casino with it, she may not be. But I'm going to get the $2,500 and bring it over here.
Is
and
that
pay
the
it.
amount of the restitution?
That's the amount of the restitution.
All right. State have any opposition to allowing Mr. Flanagan's wife to pay the restitution on behalf of Mr. Milam?
As long as I don't ever touch this money, that's fine.
All right. Then it would be dismissal restitution.
Yes, and I'll get the, does the clerk prefer, you just want the cash? You want me to put it through my escrow account, or how do y'all want to do it? Okay. Hopefully it's all still there. So. Appreciate it. Thank you. Judge, can I be excused?
You may. All right, so we are now, Mr. Krantz. 2023 CR 19526 State versus Rebecca Lambert Jobert.
And I'm going to ask for one more continuance on that matter. I've discussed it with the general. I sent an email to the clerk. I shouldn't have put it this close.
I need to, the state has indicated to me that that was going to be the case, and I don't mind resetting it one last time, but it does need to be on a date where there won't be any issues. So we'll set it for that July 8th date.
That'll be fine, Your
Since
Honor.
that's the day we know you're going to be here. So
Yes, sir.
July 8th for the sentencing hearing.
Thank you, Your Honor.
It's a date that I'm just declaring is going to be for all things criminal. Twenty 2026 CR 19869 State versus Marcus Wade Mahoney. You have criminal information, is that correct?
Yes, sir. Yes, you signed everything. It's the plea I'll read on the phone.
All right, I've been handed a document indicating that Mr. Mahoney is going to be entering a plea to count 2 of the criminal information, driving under the influence of an intoxicant, 5th offense. And he will be sentenced to a Class D felony. Is that correct?
That's
Class
correct.
D felony, 2-year sentence, suspended on probation after serving 150 days in the Cheatham County Jail. To be furloughed to an alcohol drug treatment after 17 days, with the remainder suspended to supervised probation for 2 years, with fine of $3,000 fine and cost, 8-year loss of his license, and he'll be required to undergo an alcohol and drug evaluation and follow any treatment recommendations and program. Up to 133 days of inpatient treatment. He will report to jail April the 15th of 2026 at 9 a.m. You'll have pre-sentence jail credits 1 day, is that correct?
That's what we believe to be, Your Honor, yes.
Mr. Mahoney, raise your right hand. Let's place you under oath. Step in front of that microphone. State your full legal name.
Marcus Wade Mahoney, Senior.
Mr. Mahoney, you are here today charged with a criminal information. I want to make sure you understand what you're doing in this case. Every person who is charged with a criminal offense has the right, that carries a possibility of incarceration, has the right of the grand jury of that county to review the evidence against them and to determine whether there's probable cause for the issuance of an indictment or presentment. You have the right to waive that step to expedite the disposition of your case by, instead of going through the grand jury, using what's called a criminal information. What that means is the state and your lawyer and you have agreed that you're going to sidestep the grand jury process, go ahead and bring this matter before this court on a criminal information that will allow me to have jurisdiction over your case. Do you understand that?
Yes, sir, I do.
Is that what you wish to do?
Yes, sir, I do.
Do you understand that what you're charged with, and if you and Mr. Lockhart had an opportunity to discuss the range of punishment that you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to the amended charge. Do you understand you have a right to plead not guilty, to have a speedy and public trial by jury in this court?
I do, and I do not want it.
You what?
I don't want it.
All right. You understand it, but you don't want a trial.
Yes, sir.
Do you understand that you would, if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir, I do.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir, I
Do you
understand.
understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, sir, I understand.
Do you understand you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
And do you understand that's going to result in a conviction? And that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
I do.
I've been handed a document called a Notice of DUI Punishment that purports to bear your signature on the back of that, where that indicates that you have had that explained to you, and I want you to state under oath. Have you gone over this with Mr. Lockhart, and do you fully understand the nature of that Notice of DUI Punishment?
I do.
Any questions about it at all?
No, sir.
Do you understand everything I've explained to you thus far?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer these questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we learned that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty.
Yes, sir.
Then I will ask you, are you in fact guilty of this driving under the influence of an intoxicant?
Yes, sir.
And tell me what happened.
My daughter's a heart baby. I got off work. Had a few drinks after work. She had a blowout in her diaper. She's 5 years old. She's tube fed, so she don't really eat by mouth. And yeah, I got into the car from my house. I did, and I drove down to Dollar General. I live on Bell Street. I went into Dollar General, and I guess the lady had a bad day. Me and her, I guess, had some words, whatever. So she called the cops, and I walk outside. I get into the car, and as I get into my car, I look to my driver's door, and there's an officer. I reach over and grab the keys that were in the seat, no questions asked, because I knew I've been drinking, and I just hand them to the officer. And then that's how it all played out. I asked them who called on me. They said my wife. She said she didn't. And then later on, they said somebody else called in. And
I don't know who that was, but we come to find out, I think it was a lady at Dollar General. I guess we kind of had some words with each other. She was having a bad day. I was having a bad day. And yes, sir.
Anything else, General Stevens?
Mayor General, we did get ultimately a blood sample showing 186, and he was in control of it, stated that he knew he'd been drinking, was intoxicated, and he's over and said he already knew he would be arrested for this. He does have priors, which will make it 6, out of Arkansas especially, but as part of the settlement, we're agreeing to it.
All right, are you satisfied with your attorney services?
I am.
You feel like Mr. Lockhart's done a good job of representing you confidently?
Very good job.
Mr. Lockhart, do you know of any reason he should not enter this plea?
No, sir.
Then Marcus W. Mahoney Senior, upon your plea of guilty to count 2 of this criminal information, I find you guilty of driving under the influence of an intoxicant, 5th offense, sentence you to 2 years in the Tennessee Department of Corrections. That will be as a Class D felony. That will be suspended to probation after serving 150 days in the Cheatham County Jail. And you can be furloughed to the alcohol drug treatment after 17 days, with the remainder suspended to supervised probation for 2 years. Fine and cost, a $3,000 fine and cost, 8-year loss of license. You're required to undergo an alcohol and drug evaluation and treatment program. And you can get credit for up to 133 days of inpatient treatment. And you will report to the jail April 15th, 2026 at 9 a.m. to begin serving that sentence. Now, you're on probation right now. If you get behind the wheel of a car, then you're going to serve that 2 years. I'm talking about between now and the time you report to jail.
Yes.
If you get behind the wheel of a car for any purpose, then you're going to violate your probation, and I will send you to jail for 2 years plus an additional charge. You understand that?
Yes, sir, I do.
That is the judgment of the court. Thank you.
Thank you, Judge.
2026 019-872 State versus Abigail Lee Miller.
Your Honor, that is an information, and we do have a signed plea form in that matter. The disposition is on count 1 of the Schedule 1 drugs, a B felony. A B felony reduced to C, attempted possession with intent. And count 2, the Schedule 6 drugs, as an E felony, possession with intent. And I apologize, on count 1, it's 3 years probation with the $2,000 fine. On count 2 is 2 years probation, and that'll be concurrent to count 1. Then in count 3, the possession of a firearm is going to be reduced to attempted possession. That incident would be 2 years probation, concurrent with counts 1 and count 2. And then in number 4, the possession of the paraphernalia, that's to run consecutive for the 11/29. So what we're going to have is a total probation of a period of 4 years. Ms. Miller resides in Kentucky, so this probation will be transferred up there subject to your approval. What did I do wrong?
No, just pursuant, Judge, this is pursuant to.
Oh.
35.
I was like, who knows? And there's General Hoddle, and it is his case, Your Honor. He's going to want you up here to speak loudly so that the case report can take it down. Okay? Thank you.
All right, this shows it was the criminal information. Do we have the criminal information?
Yes, Your Honor.
You have it there. Let's go ahead and file it. Everybody signed off on it?
Not.
What?
Not all of me, Your Honor.
Okay. Here is also. All right. Ms. Miller, raise your right hand. Let's place you under oath.
Yes.
Please state your name for the record, please.
Abigail Lee Miller.
Ms. Miller, I want to go over with you the rights that you have, but the first thing I want to talk to you about is you've heard me just a moment ago talk about this criminal information process. You heard me state that anyone who is charged with a criminal offense that carries the possibility of incarceration has the right to have the grand jury of that county consider the charges against them and the evidence and determine whether or not there is sufficient probable cause to even warrant the issuance of an indictment or presentment against them. Do you understand that?
Yes, Your Honor.
Do you understand that you can waive that step and expedite the entry of a disposition in your case by waiving your right to a grand jury hearing and having a criminal information presented to the court? And that's what I'm told is being done today. Is that what you wish to do?
Yes, Your Honor.
Do you understand what you're charged with? And have you and your lawyers gone over that information and the evidence against you and talked about the range of punishments you're facing as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty to these charges according to this agreement. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury?
Yes.
Do you understand that if you went to trial, you'd have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
Do you understand that if you went to trial, you and your lawyers could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes. Your Honor.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea of guilty, you're waiving your right to a hearing and to an appeal? All I'm going to do is approve what your lawyers have worked out.
Yes, Your Honor.
Now, because you have no prior criminal record, and I assume this has been cleared through the background check, through TBI?
Yes, sir.
All right.
Ms. Salinas presented that to the court as well.
All right. Because of the fact that you have no prior record and the Tennessee Bureau of Investigation has verified that, then you're being allowed to enter this plea under a specific statute called judicial diversion. And what it is Tennessee Code Annotated 4035-313. What that means is you're handing me a plea on all of these charges. I'm going to put that into the court file. And you're going to be on probation for the period of time, if I understood correctly, it was 4 years total.
Yes.
And as a result of that, if you do everything you're supposed to do, stay out of trouble, don't commit any new offenses, then at the end of that 4-year period, if you've done everything you're supposed to, you can apply to have your record expunged. And it will be as though this case never happened. It'll wipe clean from your record. On the other hand, if you violate the terms of your probation or you commit some new offense and that violates your probation, then not only will you go to prison to serve that sentence, but it will become a permanent conviction on your record to ensure that the future that will be considered in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You need to also understand that there is a provision under the statute that says that if you violate your probation, you can be brought back before the court and re-sentenced within the range of punishment for that offense. So this 4-year sentence could be greater if you violate your probation. Do you understand everything I've explained to you?
Yes, Your Honor.
Do you wish to waive your right to a hearing and to an appeal according to this agreement?
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No, sir.
You understand if you plead guilty, the court of the state could ask you questions about these offenses. And if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you are lying under oath. You understand that?
Yes,
I have to
sir.
have you answer
Oh,
verbally.
yes, sir.
All right, then do you understand I cannot accept your plea unless I'm satisfied you are in fact guilty of these charges and that you are there are facts to support it?
Yes, sir.
All right. Then are you guilty of these charges?
Yes, sir.
Tell me what happened.
He just wants to highlight what happened on that day.
I have to have facts supported to me rather than just accepting a guilty plea. Were you in possession of drugs on this occasion?
Yes, sir. We
Right.
just got pulled over with stuff on us.
What kind of drugs were they?
Just marijuana, shrooms, edibles.
All right. Anything further, Mr. Hodgson, that you want to add to it?
A large amount of drugs, paraphernalia, cash, bags, scales, as well as
All right. Are you satisfied with your attorney services?
Yes, Your Honor.
Do you think that they have both done a good job of representing
Yes,
you?
I love them.
Ms. Fordyce or Ms. Salinas, do either of you have any reason she should not enter this plea?
No, you're right.
All right, anything further from the state then?
Yes.
Then Abigail Lee Miller, was there,
Excuse me?
is there anything else? I'm sorry.
Yes, sir.
All right. Then Abigail Lee Miller and docket number 19872, upon your plea of guilty to count one, a Schedule 1 drug possession, Schedule B, you're ordered to be placed on probation for 3 years and ordered to pay a $2,000 fine. Count 2, you're ordered to be on probation for 2 years, and that will be concurrent with count 1. Count 3, you're ordered to be on probation for 2 years, and that will be concurrent with count 1 and 2. And count 4, you're found guilty of possession, or you're placed on probation rather for possession for 11 months and 29 days in order to pay a $250 fine. That will run consecutively, and that will effectively be a 4-year probation. And again, I'm stating it as probation because you have not yet been convicted of those crimes and sentenced to those crimes, because we've deferred that. So you will be allowed to transfer your probation to Kentucky where you reside, so long as the probation department complies with that. So thank you.
Thank you.
You are welcome. Twenty 2025-019-808, State versus Aaron Patrick Northcutt. Mr. Jake Locker.
Your Honor, please.
All right.
Please step outside.
All right, let's go on down. Docket number 2017, CR 18322, State versus Joshua A. Widener, Public Defender.
Yes, Judge, I represent Mr. Widener. He's being housed in Davidson County. He's got some pending charges that are set. I think he's getting arraigned in April. If we could just give him a May court date.
May 26th.
Perfect. Thank you, Judge.
2025-019-795, State versus Billy Michael Williams. All right. General Sagi, good to see you outside of Sprouts. So,
I don't know where Mr. Locker is.
Billy Michael Williams.
Mr. Williams, come on up. This was plea, Your Honor. And I found Mr. Northcutt. He had gone to the restroom.
All right, what are we doing in Mr. Williams' case?
She's gonna be entering a guilty plea to count 3 of the indictment.
Count 3, aggravated assault. You'll be pleading to count 3 and receive a sentence of 3 years. Tennessee Department of Corrections as a range 1 offender at a statutory 100% release eligibility. Sentence is suspended to 3 years supervised probation, no contact with Capser Hall, Michael Harden, or Chandler Thompson, 20 hours of public service work. He must also complete anger management course, and he's not allowed at Hustle Recovery or their property. No contact with the residents of Hustle Recovery, and he'll be ordered to pay the court costs. Mr. Williams, raise your right hand. Let's place you under oath.
I do.
Thank you. You can put your hand down. State your full name for the record.
Billy Michael Williams.
Mr. Williams, you heard me say what the agreement is, but have you seen or been shown a copy of the charges against you and gone over them with Mr. Lockhart? And you and he discussed the range of punishments you're facing as well as any possible defenses you might have?
Yes.
Well, it's indicated that you want to enter a plea of guilty to this charge according to this agreement. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes.
Do you understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
I do.
Do you understand that at trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
I do.
Do you understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
I do.
Do you understand that at trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
I do.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
I do.
Do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
I do.
Do you understand everything I've explained to you?
I do.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
Do you understand if you plead guilty, the court of the state could ask you questions about these offenses or this offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you are lying under oath?
I do.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
Do you understand? All right, then I will ask you this. Are you guilty of the charge that you're pleading guilty? Are you guilty of this aggravated assault charge?
Yes, sir.
Tell me what happened.
I knocked over the trash cans and I went back to go pick them up and they all ran out on me and it led to an argument.
Led to an argument. All right, let's have the state supplement those facts.
Case number 19795 will proceed to trial. The state's proof would show that on September the 9th, 2025, Mr. Williams is a resident near the Hustle Recovery. There have been an altercation with the trash cans outside. There's a video of Mr. Williams driving down, leaning outside of his vehicle and brandishing a firearm while 3 individuals from Hustle Recovery are outside.
And this is on video?
This is on video.
Right.
Where he was screaming profusely at them and waving his gun around. He did not fire the weapon and then he drove. This did happen in Cheatham County. He's pleading.
All right, Mr. Williams, are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Lockhart's done a good job of representing you competently?
I do.
Mr. Lockhart, do you know of any reason you should not enter this plea?
I do not, Your Honor.
Then Billy Williams and docket number 19795, upon your plea of guilty to count 3 of the indictment, I find you guilty, sentence you to 3 years in Tennessee Department of Corrections. That will be suspended to supervised probation. That is as a 100% release eligibility if you were to have to serve that sentence. You're to have no contact with Capser Hall, Michael Harden, Chandler Thompson. Or to perform 20 hours of public service work and complete an anger management course. You are not allowed to have any contact with Hustle Recovery or their property or the residents of Hustle Recovery. You're also ordered to pay the court costs. He needs to see the probation department.
Thank you, Your Honor.
You said you had your other client. Now, Mr. Lockhart.
Yes, Your Honor, Mr. Northcutt.
All right, Mr. Northcutt. What are we doing on Mr. Northcutt?
Your Honor, he's gonna be entering a plea to aggravated stalking. He'll receive. You've got the judgment?
I do.
All right. There are several conditions that Your Honor will need to go through with him as a condition of this probation in regard to email and social media.
All right, I've been handed a judgment form that will sign after the entry of this plea, and this does contain specific conditions. He is going to be entering to a plea to a felony charge of is it especially aggravated? Aggravated stalking.
Yes, Your Honor.
And sentence of 3 years suspended to probation. But there are additional charges, and you need to make sure you understand this. Number one, you are going to be serving the sentence outside of the range. You are to have no contact with Chelsea Barnes. You shall refrain from making any social media posts about Chelsea Barnes. You shall report to your probation officer in person. You're to wear a GPS ankle monitor for 1 year or the sentence. If there are no violations, the defendant must disclose all email and social media account information to the state's probation. He will be subject to having those accounts checked by state's probation. Now, the ankle monitor is for 1 year.
For 1 year, Your Honor, he's been wearing it so far. The big concerns in this particular case is a lot of social media posts. If the monitor is not, he hasn't had any violations, I can see that it can come off as it's not the main concern.
After 1 year, if no violations, it can be removed.
Yes,
All right, Mr. Northcutt, raise your right hand. Let's place you under oath.
Yes, ma'am.
Thank you. Step up to that microphone. State your full name for the record.
Aaron Patrick Northcutt.
Mr. Northcutt, you are here today based on an indictment charging you with especially aggravated stalking, but you are pleading to aggravated stalking, a lesser charge. And you've heard that your sentence will be 3 years, which is outside the range. But do you understand what you're charged with? And you've seen or been shown a copy of those charges and talked them over with Mr. Locker, and you and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to this charge. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand if we had that trial, you would have the right to have a lawyer, and if you could not afford your own, we would appoint one for you?
Yes, sir.
Do you understand if you went to trial, you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out with the state. Do you understand those conditions are going to apply to your sentence? Do you understand that?
Yes, sir.
And do you understand this is going to result in a conviction, a felony conviction that will be on your record in the future to make more severe the punishment you received if you were ever again convicted of a crime?
Yeah.
You understand everything I've explained to you? Can I answer yes or no?
Yes.
Do you want to plead guilty according to this agreement to waive your right to a trial and to an appeal?
Yeah.
If you plead guilty today, do you understand the state or the court could ask you questions about this offense? And if you answer those questions under oath on the record in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you are lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yeah.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty?
Yes.
Then are you guilty of this stalking charge?
Yes.
Do you want to lay the foundation, General?
Your Honor, on June 29th, Officer Tiffany Renendez responded to Kingston Springs and respond to a report of stalking. She spoke to Chelsea Barnes. Chelsea Barnes let her know that in between June 25th and June 27th and June 29th, that there had been multiple social media posts by Mr. Northcutt referencing Miss Barnes, referencing the order of protection that had previously been granted, also making comments and referencing her by her initials of CB on the internet and through social media. He does have a prior conviction of stalking, and that would be the basis for the plea, Your Honor.
All right, Mr. Northcutt, do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
Are you satisfied with your attorney's services?
I guess.
You guess?
Yeah.
Now, you have the right to say, no, I'm not happy with this, and you can go
I
to
mean, I'm
trial.
not happy about a felony. No.
Understand. That would be something that you might have thought through before you began engaging in the conduct. I'll just say that. But what I'm asking you is that do you have some problem with your lawyer services in this case?
No.
Mr. Lockhart, do you know of any reason he should not enter this plea?
I didn't. If he thinks this is not a good deal, I'll be happy to set this.
Mr. Northcutt, I don't care whether you enter this plea or not. If you don't enter this plea, you're going back to the original charge of especially aggravated stalking. And we will set you a trial date and give you a speedy trial as we can. But I need you to understand that I'm not going to have a situation entered where you come back later and say, well, I wasn't really happy with my lawyer services. I don't think he did a good job. And so, but I went ahead and took the plea because the judge forced me to do it. I don't care. If you don't want to do this, then we'll go back to the original especially aggravated charge. You've been through this before. The state has laid out what their evidence would be at trial. So you might have an idea of whether or not you're looking at being convicted or not. So you want to step aside and talk this over with your lawyer to make sure about this?
It's okay.
There are a lot of times people find themselves in a position of their own making that they don't like any of the results of what happens. There's no good way out, so to speak. And sometimes you have to make the best of a bad situation. I'm going to take it that that's what you feel like you're in. You're trying to make the best of a bad situation. But I need you to stay on the record that you're satisfied that your lawyer has done a good job of representing you.
Yes.
So do you state that?
Yes.
All right, Mr. Lockhart, now do you have any problems with you've made it clear to him that he can withdraw this plea and go to trial?
I think it's in his best interest. The proof is overwhelming. They have copies of the social media post. He does have a previous conviction.
I understand, Mr. North. I'm sorry for cutting you off. I understand Mr. Northcutt is not happy about having a felony conviction. The problem is that this course of conduct that landed you here in this courtroom is why you have a felony. The statutes are what they are. A lot of times people commit crimes and only to find out, gosh, that's a lot more severe than I thought it was going to be. So it's a lesson learned. All right. Anything further from the state?
No, Your Honor.
Then Aaron P. Northcutt and docket number 19808, upon your plea of guilty to aggravated stalking, I find you guilty, sentence you to 3 years Tennessee Department of Corrections. You will be suspended to serve that on probation. However, there are additional conditions. You have agreed to serve this sentence outside of the range. You shall have no contact with Chelsea Barnes, and you shall make no social media posts about Chelsea Barnes. And that means you shall not post them under your name. You shall not post them under some assumed name. So you can't catfish or whatever that term is and try to come in under some other assumed name and make comments. You'll report to your state probation officer in person. You'll wear that GPS ankle monitor for at least 1 year. And if there's no violations, you can see about having that removed. But you'll have to have an order submitted to the judge to remove it. You'll disclose all of your email and social media account information to your probation officer, and you're subject to having those accounts checked by state probation. Now, I understand you're not happy about this felony plea, but I want to make it clear to you, you've now been found guilty and sentenced to probation. It will, there's an old, John Milton was a famous English writer, and he wrote Paradise Lost. You probably have never heard of that, but it was a famous book, and he likens the person being dangled over the bowels of hell by a string. And that's, for some reason, stuck with me all my years. You're dangling over the State Department of Corrections by a single string that I'm holding the end to. And if you violate your probation by making some report or contacting this young woman again, I'm gonna let that string go and you're gonna go to prison for 3 years, plus any additional charges. You understand that? Well, I hope you've learned your lesson, but I somehow questioned that. But anyway, you see your probation officer.
Thank you.
All right. Looks like 2026-19854, Rebecca's case, Sype, public defender. This is the one that's set for 1:30, correct? 1 o'clock.
Yes.
1 o'clock.
I do not see her yet, but I will call her on the break.
This is the cruelty to animals where we have the ARC Animal Rescue Corporation.
This is a bird case, Judge, yes.
All right, and so the hearing at 1 is over this, the motion. I just want to make clear on the record, this is the motion that the ARC has filed to require a bond to be set.
Correct.
And it's also your motion for visitation with the birds and
That is-
other animals.
All of that is correct. We would be moving to continue the bird lawyer's motion for
Bird lawyer,
the bird lawyer's motion for the bond thing today, as in that we just got all of the financial discovery. That would be the topic of
well,
it.
let's let her get here and then we'll
Okay.
talk about it. But so that we're clear, if that were to be continued, you still want to pursue the motion that your client filed, a pro se motion for visitation with the birds and other animals that were removed from her custody.
Absolutely, Judge.
And we're talking every other weekend, or I'll let you argue that when we get to the.
Correct.
point, so,
Correct.
right. We had Taylor Timothy Teague. Did we deal with him?
I don't know. I guess he didn't get transported, Judge, but we were going to continue that anyway. He's got pending charges. We discussed it. We actually said to move it to July, so he must have some May issues.
So we're moving it to July,
Well, let's just put it on May so I don't lose track.
all right, May 26th. Right, and then I have 2025-019797 State versus Jeremy Greenwood. Mr. Lockett, that is your. Most of the time when there's criminal docket case, you can't swing a dead cat without hitting a locket. And then now I can't keep him in the courtroom. So. Probably wasn't an appropriate joke to make on a day for an animal cruelty case. We are talking about Mr. Jeremy Greenwood.
Yes, Your Honor. We've got a plea offer of probation, but he's advised me that he has checked into treatment because he needed treatment.
Well, we had you have a motion to set aside a capias.
I understand.
Because we had a failure to appear.
That's,
And where is he in treatment?
that doesn't put me in a good position. I haven't got documentation yet, Your Honor, so.
Let's do this. Let's just pass it on the docket. I don't care if you set it for next month, but if you produce proof to satisfy Judge Wallace that he's where he ought to be and that, you can set aside the capias. If Judge Wallace sets it aside, I'm okay with that. So,
Yes, Your Honor.
April 14th would be your next day.
I'll put it on there, Your Honor. Thank
Right.
you.
I skipped over a Maurice E. Wilson, docket number 2025-CR19783. Ms. Brady Wilkerson. All right. All right, I've been handed a document indicating Mr. Wilson is going to be entering a plea of nono contendere to count 1, simple possession, Class A misdemeanor, receive a sentence of 11 months, 29 days in the county jail, suspended to probation, $250 fine. Count 2, possession of a weapon by a convicted felon would be 8 years in the Tennessee Department of Corrections, suspended to state probation, And those two would be concurrent with one another. Mr. Wilson, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record.
Maurice Eugene Wilson.
Mr. Wilson, you're here today charged with these two counts. You've heard me go over what the agreement is, but have you seen or been shown a copy of those charges and talked them over with Ms. Brady Wilkerson and discussed with her the range of punishments you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere. What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And I'm going to use their evidence to find you guilty according to this agreement, even though you don't admit anything. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that if you went to trial, you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that at trial you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is prove what your lawyer and the state have agreed upon.
Yes, sir.
But that's going to result in two convictions, one misdemeanor, one felony, that will now be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
I do.
You want to waive your right to a trial and to an appeal by entering this plea of no contest.
I do.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand that I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty?
Yes, sir.
Then listen as the state tells me what their evidence would be if this case went to before a jury. If you'll point that microphone so our record is, we're recording everything that's being said today. That's why I need to make sure everything's being said into a microphone.
In docket 19783 on February the 23rd, 2025, the defendant was driving a vehicle down Highway 12 South. It was pulled over for a suspected illegal tent. While checking the tent, the officer with Ashland City noticed that there was a strong odor of marijuana coming from the vehicle. At that point in time, the defendant was asked about that odor. He produced 2 rolled marijuana cigarettes. There was also a black backpack in the passenger seat that was found to have a loaded Glock 19 handgun. After the officers ran a criminal history check, he did have a prior felony for selling narcotics.
I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You believe Ms. Brady has done a good job of representing you competently?
Yes, I do.
Do you know of any reason you should not enter this plea? Anything further from the state?
No, Your Honor.
Then Maurice Wilson and docket number 19783, upon your plea of count 1 of no contest, I find you guilty, sentence you to 11 months and 29 days in the county jail, suspended to state probation. You're ordered to pay a $250 fine and costs. Count 2, you're found guilty, sentenced to 8 years, Tennessee Department of Corrections, suspended to state probation. Those counts are running concurrently with one another. You'll need to see the probation department. Thank you. CR 19680, State versus Austin Gordon Simpkins.
Your Honor, I think that's set for either 1 or 1:30 for a hearing. Really arguing about today is the visitation portion of Mr. Pugh's motion.
The what?
He has asked that Mr. Simpkins, he currently has a condition of his bond because of the charges not to be around any children. He was asking, I'm assuming Mr. Simpkins has some custody matters in juvenile court.
Okay.
And he was asking the court to amend his bond conditions to mirror whatever the
All right,
juvenile court.
I understand. Thank you. 2024 CR 19606, State versus Wyatt Lester. That's Mr. Flanagan's case. That's a 1:30 plea, okay. All right, 1:30, is it 1:30 or 1? Mr. Flanagan says he needs to do it at 1 o'clock. Can everybody be here at 1 for that?
I think that's Mr. Stevens or General Stevens' case.
Anyone here who has had a case that you understood you personally were supposed to be here for that case and your name has not been called? All right. Mr. Walwins, anything you need to announce on your case, Mr. Fritz? Or I'm about to take a recess and allow the inmates to be brought up. So that's why I was going to say if there's anything we need to deal with before.
We could deal with Ricky Palmer real quickly, Your Honor. He's set for a VOP arraignment here today, but I believe tomorrow he has some pretty serious charges in general sessions where the public defender is going to have a conflict. They technically would not on his violation of probation, but two things. I think it's set for April, and I would like it to track in May because that's going to be my case. And
May 26th.
But he also probably needs a different lawyer that will not have a conflict just to globally be able to handle everything. Although I guess tomorrow, has he been appointed an attorney in general sessions? I don't think so.
Well, do we know that it's going to be?
He's got an attempted first degree murder charge is what he's got.
Attempted first degree murder.
Allegation would be that he shot at a Cheatham County deputy. So we were just, to make it simpler, whoever gets appointed there should probably have his VOP here. Because that's, obviously those charges are coming up here.
So any reason I can't appoint Eric Lockhart to represent the defendant, you know, of any conflict he would have?
He wouldn't have a conflict, but it would need to be on your honor's docket, not Judge Lockhart-Mash's. Yeah, that'd be the only issue.
Well, we'll make that happen. All right, we'll appoint Mr. Eric Lockhart to represent Mr. Ricky Palmer, and he can be appointed in general sessions.
I will let Judge Maxey know.
With Judge Maxey one anyway, so. All right, then we'll go ahead and take our recess for the mid-morning. And Ms. Brady, where did she go? You had several people that were in custody that you were not in the courtroom, and I just put them on the second call. We're gonna go ahead and bring them down. So we'll have all of your clients brought down as well. We're gonna stand in recess for at least 15 minutes until the inmates are brought in.
All right.
Well, it's my understanding we have one inmate that we need to go ahead and take care of.
Case number 6, docket number 19273, Sandra Winston.
And Judge, this is my client, as we've said over, she's going to admit she's in violation and be reinstated, but also transferred.
All right. Ms. Winston, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record. What is your full name?
Sandra Ann Winstead.
Ms. Winstead,
Sorry.
you're here today on a violation of probation. Do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
I do.
Do you understand that if we had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with the public defender?
I do.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
You understand that by pleading guilty, you're waiving your right to that hearing and that appeal. All I'm going to do is approve what your lawyer has worked out.
I do.
You understand that's going to be to reinstate you to probation on time served.
I do.
All right. Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to that hearing?
Yes, sir.
Then upon your plea of guilty, I find you guilty or that you be revoked to serve your sentence, but on agreement with the state and on time served, we will reinstate you to probation and transfer you to community corrections for the balance of your sentence.
Oh,
all right?
Okay, thank you.
Thank you.
Thank you.
We are now ready for the male inmates. And anybody have anything that we can handle while we're waiting on those inmates?
I think we could go forward with Ms. Sipes' motion for the visitation of the birds, because the bird lawyer is not a non-party and not involved in that at all. It has no right to testify, so.
Well, is the representative from the ARC here?
No, but she doesn't, she can't testify.
But they are the ones in possession of the animals that we're talking about, right?
Correct.
So they would even though they might not necessarily be a party as far as the participant in having the legal rights, they are the ones who have possession of the animals, and therefore any kind of visitation would have to be coordinated with them if I granted it.
Sure.
It would have to be coordinated with them, so I think it would be more appropriate to wait till that individual is here.
Okay.
And we have it set at 1 o'clock or 1:30, one of the two. So.
Okay.
All right. All right, who do we have?
Okay, we have on page number 1, docket number 19303, Keith Collins. Wait,
All right. This is a violation of community corrections.
Yes, Your Honor, I can have a moment to speak.
All right. There's also an amended charge, since you've seen that, she needs to be arraigned on. Officer, if you'll hand this to her. Excuse me. Let's go ahead with the next inmate.
okay, we have on page number 3, docket number 19543, Jimmy Nether.
Freddie Wilkerson, you want to explain to me what this is?
Your Honor, Mr. Netherton has filed a pro se motion and, you know, I'm not really involved in that necessarily, but I wanted to be sure to get it on your docket so that he could make his argument to the court about why he believes that his VOP judgment should be set aside, I suppose.
Well, number one, this is a judgment he's seeking to modify that was entered by Judge Lockhart Mash in May of 2024. So in my opinion, if he's seeking to modify that judgment, she would be the appropriate person to enter it. His motion says, I had come to court on May 28th and received a sentence of 3 years probation upon release to a rehab, Jack Jean Shelter, and upon completion of 6 months. I have a hold out of Sumner County. I may be reading an older, but I guess I'm reading that older. Right. Motion to appeal my sentence that's in effect. I need help by the rehab or other drug court. I hear the law is changing for drug court and willing to wait or do whatever I have to be able to better myself and get back out there for my kids. I know I've made a mistake and have consequences, but have never received help as in rehab or anything like that. I need help. The law is rehabilitation before incarceration. It's interesting. Thank you for your time. Well, apparently what he's wanting to modify is the violation of probation revocation order that was entered in October of 2025. And in that order, it was Judge Turnbow that entered the order, and it's basically he conceded the violation was revoked to serve his 3-year sentence. Is that what I'm understanding? And it is now, he's filed in March of this year a motion to appeal your sentence. Problem is that the period of time for you to appeal a judgment of this court is 30 days from the entry of the judgment. That judgment order was entered on October the 28th of 2025. So November the 28th of 2025 would have been the last day for you to file a notice of appeal of that. So you are now in a situation where that your request to appeal that has expired. In the body of what you're saying is apparently that you are asking to be allowed to go into rehab rather than simply being incarcerated. And to do that, you'll have to go before the judge who revoked you and serve your sentence. So Judge Turnbow will be here when? We'll move you to June and let Judge Turnbow consider whether or not to give you rehab rather than serve the balance of your sentence. June what? June 30th.
All right, thank you, Your Honor.
All right. Who we got?
Page number 2, docket number 19710, 19713, John Frank.
Judge, Mr. France is not applying. That's going to be completed today. Judge, there's 2 case numbers. One is dealing with General Sylvie. The other is dealing with General Willoughby. Case number 19710, that is for General Sylvie. That is going to be amended to simple assault, a misdemeanor. That'll be 11 months to 29 days, suspended to supervised probation, credit for time served, and no contact victim. The rest of the counts will be dismissed in that case. And then as well as 19713, that's going to be amended to theft under 1,000, another a misdemeanor. That will be 1129, suspended to supervised probation as well. That will run concurrent to 19710. I believe that's the only count in there, but anything else would be dismissed in any other cases. He's got jail credit from 9/8 to 9/10, 10/23 to 10/25, and 12/3 to 12/19 of 2024. Then 1/8 to 1/15 of 2025, and 3/10 to 3/30 today's date of 2026.
All right, Mr. Krantz, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Jonathan Krantz.
Mr. Krantz, you're here today on a couple of different indictments. You've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of those charges and talked them over with your lawyer? And you and Mr. Vaughn discuss the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest or nolo contendere. Do you understand that that means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when General Sylvie tells me what their evidence will be if this case went to trial? And I will use her evidence that she presents to me to find you guilty according to this agreement. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and have a speedy and public trial by jury?
Yes, sir.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that if at trial you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
Do you understand that that's going to result in 2 misdemeanor convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
I do.
Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
It is.
Anybody forcing you to do this against your
No,
will?
sir.
Do you understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of this charge?
Yes, sir.
Then listen as the state steps up to the microphone and tells us what their evidence would be if this case went to trial.
Your Honor, on September 8th of 2024, Deputy Sutton responded to a call for help at the Twice Daily on Jackson Phelps Road. He ended up going to 1001 Carl Perry Road. He made contact with Alexandria Smith, who stated that she had been in an argument with Mr. Krantz over owing $800. And in her statement regarding the argument, she said that there had been a firearm that had been discharged into the air and that she was in fear and sitting on the ground crying as a result. They did have contact with Mr. Krantz, spoke to Mr. Krantz about the incident. He had a similar story, almost the same, but it was missing and did not have any mention of a firearm or discharging a firearm. Between the two stories, the state has come to this agreement that whatever did ensue, there was an argument in which Ms. Smith was placed in fear of imminent bodily injury. Therefore, we have brought it down to a simple assault.
All right. Mr. Krantz, I'm not asking that you agree with those facts.
I have a whole separate case.
All right. This is the theft.
Yes, sir.
All right.
Can we
So
do
what
that
are the
now?
facts in the theft case?
In docket 19713 on January 8th, 2025, officers went to where the defendant was living here in Cheatham County for a knock and talk about a drug transaction. Noticed a new BMW motorcycle, ran the VIN number. It came back stolen. There was a trailer as well on the property. It was stolen out of Nashville as well. Mr. Krantz admitted to being in possession of those items, but just stated that he was borrowing it, I think, to fix it up for a friend. And once that was done, he was going to take it back.
Again, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? Move that microphone back. There you go.
Yes, sir.
Do you still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Vaughn has done a good job of representing you confidently.
Yes, sir.
Mr. Vaughn, you know of any reason he should not enter this plea? Anything further from either one of the state representatives? Take it by your silence. The answer is no.
No from both of us.
Then Jonathan Krantz, docket number 19710, upon your plea of no contest to simple assault, I find you guilty, sentence you to 11 months 29 days in the county jail that will be suspended to supervised probation with credit for time served and have no contact with the victim. Docket number 19713, upon your plea to the amended charge of theft, I find you guilty, sentence you to 11 months and 29 days in county jail. That will be suspended to supervised probation. That will also be served concurrently with the prior case. And your prior jail credits are all set forth by Mr. Vaughn on this document. So, thank you. He needs to see probation. Who else we have?
Great.
Page number 4, document number 19849, Tracy Perry.
Judge, this Perry is also mine. That'll be complete. Mr. Perry's got a multiple count indictment, Your Honor. He is going to be pleading no contest to count 1 and 2. Both are evading arrest. Count 1 is of the felony variety, and count 2 is of a misdemeanor variety. He will receive 4 years in TDOC suspended to the state probation as to count 1, and 1129 suspended to state probation, which will run concurrent with count 1 on count 2. All other counts can be dismissed. This will be a range one. He's got jail credit from 12, 27, and 25.
Perry, raise your right hand. Let's place you under oath.
Yes.
Thank you. State your full name for the record.
Trace C. Perry.
Mr. Perry, you're here today charged with 2 different counts, and you've heard your lawyer go over what the agreement is. But have you been shown a copy of the charges, talked them over with Mr. Vaughn, you and he discussed the range of punishment you're facing, as well as any possible defenses you might have to the state's evidence?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of nolo contendere. You may have just heard me explain. That means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And I'm going to use their evidence to find you guilty according to this agreement. Does that make sense?
Yes, Your Honor.
Do you understand, however, that you can plead not guilty and have a speedy and public trial by jury in this court?
Yes, Your Honor.
Do you understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you could not afford your own? Of course, we've done that with a public defender.
Yes, Your Honor.
You understand that trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you would, and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand that you would not have to testify or prove anything at your trial, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state.
Yes, Your Honor.
And do you understand that's going to result in you having 2 additional convictions, 1 felony, 1 misdemeanor, that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
Yes.
Is your decision to plead no contest today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, Your Honor.
And listen as the state tells me what their evidence would be if this case went to trial.
Yes, Your Honor, in docket 19849 on December 26, 2025. Initially, deputies were notified of a reckless driver entering Cheatham County, I believe from Dixon County. They picked up that pursuit, chased the defendant for a while, attempted to spike strip his vehicle. That was not successful. And they, because of the nature of the chase, chose to terminate the pursuit for safety concerns. At a later time, Ashton City on that same date picked up the pursuit. And again, the defendant was driving erratically all over the road, trying to evade police. He was eventually apprehended and identified by both agencies.
And again, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, Your Honor.
You still wish to plead no contest?
Yes.
Are you satisfied with your attorney's services?
Yes,
You feel like Mr. Bond has done a good job of representing you competently?
absolutely.
Mr. Bond, you know of any reason he should not enter this plea? Anything further from the state?
No, Your Honor.
Then is it Tracy Perry?
Trace.
Trace Perry. Upon your plea of no contest to count one, I find you guilty. Sentence you to 4 years, Tennessee Department of Corrections, suspended to state probation on time served. Count two, evading arrest, you're sentenced to 11 months, 29 days in the county jail. That will be suspended to state probation to be served concurrently with count one. You get pre-sentence jail credits from December the 27th, 2025 until today. All right, thank you. He
Thank
needs
you.
to see probation.
And the second call, Mr. Collins, docket number 19303.
Good morning,
Good
Mr.
morning.
Good morning, Your Honor. This is Mr. Collins. He is charged with a violation of community corrections. He is going to admit to the violation and will be in custody to start out the remainder of the underlying sentence.
Yes, sir.
Okay, he'll be in custody to serve out a sentence.
Yes, Your Honor.
All right. And Mr. Collins will get credit for any time served, correct? All right, Mr. Collins, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Markway Collins.
Mr. Collins, you are here today charged with violation of probation, actually violation of community corrections. It's my understanding that you want to enter a plea, but do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your community corrections probation?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand by pleading guilty, you're waiving your right to that hearing, to that appeal. All I'm going to do is revoke you to serve the balance of your sentence with credit for all your time.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement?
Yes, sir.
Then upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence with credit for all your time.
Yes, sir.
All right, thank you.
Thank you.
See you next time you come.
Do we have anybody ready?
Have Mr. Holt up here.
All right. Mr. Holt, he is yet to be arraigned on this charge. So, Mr. Holt, you are here today to be arraigned on an indictment charging you with theft of property from $10,000 to $60,000, evading arrest with risk of death or injury by a vehicle involved, theft up to $1,000, possession of burglary tools, and simple possession of a Schedule 6 drug. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
All right, I'm going to appoint the public defender to represent you. Mr. Vaughn with the public defender's office is here.
We will waive formal reading and their plea not guilty.
Plea of not guilty is entered. We need to set a status date or trial date.
Just a plea date, Your Honor, and this is the one where I had filed to revoke his bond.
All right. Do we need to go forward with that today?
That's up to Mr. Vaughn. It's simply based on he got arrested while he was on bond. I attached the warrants to the motion, which.
All right. Let's go ahead and set a date while we have him.
Want to do your July 10?
July 10th, is that what it is?
July 8th.
14th. July 14th.
July 14th.
And we'll come back to it if we need to have that hearing on the bond revocation.
Page number 4, docket number 18767, Jerry Parker.
What are we doing?
Your Honor, it's my understanding that we're going to concede the violation and terminate his probation today.
Correct, Your Honor.
Right, so you're gonna concede the violation and put a sentence into effect.
Well,
What is the agreement? I'm sorry.
so his probation is over as of today.
Oh,
So
I
we're going
see.
to concede and he'll be released today.
Right,
Done.
so pretty simple decision to make, I would assume, if you
Yes,
just go ahead
sir.
and
Yes,
dispose
sir.
of
I
this.
agree. Yes,
You
sir.
don't want me to put your case off for a couple of
we're
No,
months?
sir. I would appreciate you not.
All right, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Jerry Joseph Parker.
Mr. Parker, you're here today on a charge of violation of probation. I want to make sure you understand your rights, although I clearly understand what you're doing. Do you understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard you violated your probation?
Yes, sir.
You understand you'd have the right to have a lawyer and have one appointed if necessary?
Yes, sir.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're waiving that hearing into that appeal. Although in this case, it's going to end up being that I'm going to find you guilty of violating your probation and terminate your probation.
Yes, sir.
The case will be over. You
Yes, sir.
understand all that? You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to that understanding?
Yes, sir.
And upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but because it expires today, I'm terminating your probation.
Yes, sir. Thanks.
Good luck to you. I hope you stay out of trouble, all right?
Thank you.
Yes, sir. Thank you.
Judge, I've explained to Mr. Holt that, so he's got charges pending out of Montgomery County. That's what the basis of the DA's revocation motion is for. I explained to him that he would not, while he is quote unquote out on bond now, he is not getting any time towards a Cheatham County sentence. He's decided to just go ahead and say, we're good.
All right, there's a statute, and Mr. Vaughn, I'm sure it's explained to you, that says that the court may revoke the bond of any person who, when they are released on bond, is arrested on another charge. They don't have to be convicted. They just simply be arrested. And that's what the state is traveling under, that you have another charge pending. So based on that, it's my understanding you've thought this through and that you're going to agree to the state revoking your bond.
Yes, sir.
All right. State's motion to revoke bond is granted.
Thank you, Your Honor.
This time will then start to accrue on the
And that was a July date, correct?
July 14th. Or anything else that we have in the morning docket then? Oh, we do have one other case. Terrelandis Fritz.
Yes, Your Honor, Spoke with General Willoughby. Your Honor, can we put this on your July date, please?
Is the state in agreement with moving it to July?
Yes, Your Honor.
July 14th.
Thank you, Your Honor.
That will likely be the last status date. That will be the final plea date, Mr. Walden.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Anything else this morning?
You made the decision to have the lady here to testify about Scram. Do you want to do that this afternoon?
This is on your motion to revoke his bond.
Yes, Your Honor.
Can we just do that right now and bring Mr. Richardson up?
It's up to you. If you want to do that, we
Well,
can.
I'd like to talk to him at least.
Okay.
We have a couple of things at 1 o'clock or 1:30, whatever it is. Mr. Flanagan's plea is going to be at 1 because he has a 2 o'clock Paddles of Pain rehab program, he said, for his knee replacement. So
Well, I just don't want her to have to sit around till 1. If we can just bring him up and have this hearing, then
you want to do it at 1?
no, I would like to do it right now.
Well, let's get him up there. Where is he?
Okay. Can we get Mr. Richardson up?
Benjamin Parker Richardson, is that correct?
I believe so, yeah.
So that leaves us at 1 o'clock with Mr. Flanagan's plea on the vehicular homicide And then the motion regarding visitation with animals removed by the ARC. And their bond issue, which Mr. Vaughn is requesting a continuance of. I must say, in 37 years of practicing law as an attorney, and now in my 12th year on the bench, I've never had to be involved in a case of visitation with birds. I have had custody of dogs in divorce cases come up, where the parties are fighting over who gets Fido, in a custody case. And I've actually, since I've been judge, awarded a split custody arrangement, 50-50 split of a dog with the parents. You don't have to write that down.
It's super interesting to come across it in first year.
Yeah.
First for me as well. Thank you, sir.
Any of you town probation officers gonna have something for me to sign? I might want to get it done, because when we finish with this hearing, we'll be lunchtime.
Your body wash smells great. Tell you about that. You've got to. These things must entertain spectators. You cannot hold good things. I was talking to Colin last night about his comment. He said, listen, Mom, when your mom's a troll and your dad's a troll, you become a master troll. And I'm like, you're right. You're a troll. You learn to troll back.
same night as Chuck comes. Come to that sauce and work on it. It's like, good night, people.
I'm hungry, please don't mention meatballs. I'm like, spend $20.
So this information is really
Today, so.
You mentioned baseball, and now I'm hungry.
Karen told me good night.
I don't even care, like, if y'all can eat your own stuff, we can eat it. Well, the thing about eating on general session is no, I would get that. I would go and get rid. I will consume food, yes. Might even, like I told my husband, because I'm hungry, I might even do the $20 included. And eat my 3 pieces. Super happy. Yeah, I think I probably just need to stick to some shit. My bank account can be that. Oh, well, we got paid for that. I have nothing on my end. You know, the little,
All right.
yes.
All right, Judge, we're ready whenever you are. We're gonna have a hearing on the bond revocation.
right, so.
Your Honor, on Mr. Benjamin Richardson, I filed a motion to revoke his bond.
Hold on just a second. Who is it we're dealing with? Mr. Richards, Benjamin Parker Richardson, correct?
Yes, Your Honor.
All right, now go.
All right, have file number 19858 and 19859. I filed this motion to revoke Mr. Richardson's bond. In
The case ending in 858, Mr. Richardson is charged with domestic assault, aggravated burglary, DUI second per se, public intox, implied consent, possession of a firearm while intoxicated, and violation of bond conditions. Now, when these cases were bound over to the grand jury, his bond was reduced from 100,000 to 25,000 with the agreement that he was to wear a scram monitor. And that would have his alcohol tracked. Now, since that date, he has had several violations through the monitoring company with nationwide electronic monitoring. And I filed those as an exhibit to the motion, Your Honor. Not only did I file that as exhibit B, I have exhibit A where the agreement for the scram monitor was placed on him. Now, I have Miss Kelly Arnold here to testify regarding the exhibit B and the monitoring and violations, Your Honor.
Right. You wish to make any sort of opening statement, Mr. Vaughn?
No, I'll wait that, Judge.
All right, we'll call your first witness.
Your Honor, I call Kelly Arnold with Nationwide Monitoring.
You'll come right up and raise your right hand and be placed under oath.
You solemnly swear affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God.
Can you state your name for the record once you get seated? I'm sorry.
It's okay. Kelly Arnold,
And where are you employed?
Nationwide Electronic Monitoring.
Okay. And how long have you been employed with them?
I've been employed with them since December, but the company that I was previous with, I have been with since 2015 in electronic monitoring.
Okay, so you have experience since 2015 on electronic monitoring. What kind of training do you have regarding being able to interpret the things that you see as electronic monitoring?
I have a Scram Level 1 training, which is understanding the components and how the
Ma'am, if
device.
you'll pull that microphone toward you a little bit, it's very, these things don't pick up unless you're almost having to talk directly into them. So,
Yes, sir.
all right, thank you.
I have a Scram Level 1 training, which is just the understanding of the components and how the device works and how to install it. I also have Level 2 training, which is court testimony and reading the reports as a custodian of records.
Okay. Are you responsible for Mr. Benjamin Richardson?
I am the custodian of records for Mr. Richardson's.
And
device.
you've brought those and provided those to the state?
Yes, ma'am.
Okay, I'm gonna go through a couple dates. Do you have your notes to be able to help you testify on those dates?
Yes, ma'am.
Okay, I want to first start, we're just gonna go chronologically. So can you tell me when Mr. Richardson was added to your company's monitoring?
December 18th of 2025.
All right. So February 1st of 2026, did you have an alert regarding Mr. Richardson?
Yes, ma'am.
What was that report? February 1st of 2026.
That was actually a confirmed consumption.
Okay. Tell me and walk me through the process of what a confirmed consumption looks like.
Okay. So the device is taking a test every 30 minutes from the skin. It's taking a air sample from the skin. So we advise them to keep the device to the leg, nothing in between it. So when alcohol is consumed, your body absorbs it, metabolizes it, and then it has to be released through your organs, your largest organ being your skin, which is your dermis. So it's a transdermal device. So every 30 minutes, that device is taking a test of the air samples. In order to confirm a consumption for alcohol, which the analysts do from Scram, the device has to make sure there are 2 readings at 0, followed by an absorption rate, a peak, and an elimination rate, followed by 2 extra points of 0. So on this day, it actually began on January 31st. It started detecting alcohol. I'm sorry. Yes, it started detecting alcohol at noon. It peaked around 12 a.m. on February 1st, and we finally reached 2 zeros on February 1st about 10 a.m. I'm sorry, 8:12 a.m.
Okay. So the way it works is it's going to detect that they've started consuming alcohol and it will just kind of give you a time frame of you start from 0 and then you finally get back to 0.
Correct.
Can't tell exactly when it was, right?
Well, you can tell when the body started absorbing the alcohol.
Okay. Can it tell, what we're used to is a BAC. So it can't say that it has reached a 0.08 or anything like that, just that there has been alcohol consumption.
So it gives us readings, but to compare them to your BAC and your BRAC is apples to oranges. Your transdermal alcohol content is different from your breath and your blood because of the way it's metabolized.
Okay. And so to be fair, it just does that it has been consumed, and that is the main thing, correct?
Correct.
Okay.
It starts analyzing the alcohol at a 0.02 for TAC, just for the record.
Okay. Now, is there anything that could cause it to trigger and say that alcohol is present, but it not necessarily be consumed?
Yes, so those are environmental factors,
Okay.
and there are tests involved in the criteria as well as the actual device to determine if it was an environmental. Usually with an environmental, you're going to see a spike up and a spike down. There's not going to be an absorption rate or an elimination rate. So you kind of have that safeguard to
Okay.
ensure that.
So to say that maybe they're going to look at body temperature.
Yes.
Okay. And so that, what would body temperature tell you as far as someone wearing a monitor?
So the body temperature, what we do when we install this device is it takes a baseline. It's going to determine the body's temperature, the IR voltage, which is the light refraction between the leg and the device, as well as any alcohol in the body. And the purpose of the temperature gauge is to ensure that there's nothing going between the leg and the bracelet. Because again, if there is something between the leg and the bracelet, they're advised that you have to ensure that nothing does do that, because we're trying to take air samples directly from the skin.
Okay. So if, let's say it had something in between and it made some sort of spike, and you look through it and you think there's conception, you kind of run those different checks and balances?
Yes, the analysts run those checks and balances. They also have a tamper criteria. So if there's something between the leg and the bracelet for more than 8 hours and no alcohol present, they're going to confirm the tamper. If they have something between the leg and the bracelet and alcohol is present, which means that you're still able to take alcohol samples from the air samples, usually socks, leggings, pants, sheets, anything that may or may not, I've pulled ham and bologna out between it as well. But anything permeable is still going to allow the alcohol to come in, but they don't always confirm it when that happens. So that's why they confirm the tamper.
Okay. So if the checks and balances regarding those different things, when the analysts look at it, don't go out, how do y'all treat that?
Can you repeat that? I'm sorry.
So if you do the checks and balances, the analysts look at it and they say that there was too much air in between or something like that. How do you guys treat those? Are those considered a positive? What do you end up doing there?
So if they cannot confirm it, we just move on. There's no violation sent to the court. As long as the analysts cannot confirm it, then we don't send a violation.
Okay. So if there's no confirmation, the checks and balances, they get a benefit of the doubt. They could have consumed, but y'all go through extra steps. So if you have a confirmation, it has gone through extra steps to make sure all the checks and balances and the monitor is working correctly for you to say that there was a consumption.
Correct.
Okay. And you said on February 1st, you did all of that process, and the analyst went through all the checks and balances, and he had a consumption on that date?
Yes, ma'am.
Okay. Now, can you tell me when the next consumption violation occurred?
The next day, it started at, it was starting at, let's see, the baseline was established at 1:14 p.m. By 8:58, we hit a peak, and 0 was not reestablished until February 3rd at 3:25 a.m., meaning that it was a multi-day consumption. So when we have multi-day consumptions, it's basically stating that because of the criteria that we have, that it has to have double zeros before and after the event, it never made it to double zeros. It just kind of either he did not quit drinking, or he didn't have enough time for the alcohol to leave his body completely to get the devil's secret.
So that was a multi-day consumption from February 2nd to February 3rd.
Yes, ma'am.
When would the next consumption date be?
Well, we actually had a confirmed tamper through that process as well, on the 2nd. Went through the 2nd to the 3rd. Then we had another multi-day peak alcohol consumption, February 3rd, beginning February 3rd through February 7th. Zero was established on Tuesday, February 3rd at 6:26 a.m. A peak of 0.063 was established on February 3rd at 6:46 p.m. And then another peak was confirmed of 0.267 on Friday, February 6th at 10:50 p.m. He did not reach double zeros again until February 7th at 9:40 a.m.
Okay. When would be the next time we see a consumption?
We had the confirmed tamper with alcohol detected on February 5th through the 9th. Another confirmed tamper with alcohol detected February 9th through February 11th. A confirmed consumption February 9th through February 10th. A confirmed tamper with alcohol detected February 11th through February 12th. Confirmed consumption February 11th through February 12th. A confirmed tamper with alcohol detected February 12th through February 14th. We had a confirmed tamper with no alcohol present on February 14th through the 15th. Confirmed tamper with alcohol detected February 24th through the 25th. Confirmed tamper with alcohol February 25th through February 27th. Confirmed alcohol consumption February 26th through February 27th. Confirmed tamper with alcohol detected February 27th through March 1st. Multi-day peak consumption February 27th through March 1st. March 1st through March 2nd, a confirmed alcohol consumption. Confirmed alcohol detected, or confirmed tamper with alcohol detected March 2nd through March 3rd. Another multi-day peak alcohol consumption March 3rd through the 5th. A confirmed tamper from March 4th through the 5th with alcohol. Multi-peak alcohol consumption March 6th through the 12th. And that's all I have.
Okay. Now, in particular, he was supposed to be in court on March, I believe, March 12th, might have been March 10th. March 10th. During that time frame of March 10th, can you tell if he was consuming alcohol when he was supposed to be at court?
Yes, that was part of the multi-peak consumption from March 6th through March 12th, where the TIC never hit zero in beginning and the ending of the event, so they had to call it a multi-day consumption.
Okay. And I have another question. So all this does is have the transdermal, does there any kind of GPS location with it?
No, ma'am.
Okay. So during that whole time frame, could he have been operating a vehicle?
He could have.
Okay. Have no other questions, Your Honor.
Ron, you have questions?
Yeah, a couple of follow-ups. So it's funny you say that. I literally wrote baloney on your ask about that because I've heard people doing that. So that's just an effort to like have sort of like a skin-like thing between the monitor.
Yes, sir. So in my first year, I was living in East Tennessee, and a lady told me that she Googled what it was like, or how to conceal alcohol while wearing a scram, and she had cured ham between her leg and the bracelet because Google told her it was cured ham. But we have seen all sorts of deli meats go between these bracelets.
Does it work?
No.
Oh.
That's why we have the test.
Okay. So we were talking about environmental factors. Would that include like a spill? Like if somebody just spilled a beer on my ankle, would it be
It would definitely trigger an alert, but it's what I had referenced earlier with the spike of alcohol. You know,
Yeah.
when you put hand sanitizer on, you know, that alcohol's on your hands briefly and then it dries instantaneously. and
Right.
It's the same with alcohol. We have plenty of people that are bartenders and you'll see that, you know, you're looking for more of a gradual bell curve.
Not just
But
a
with
pop, pop.
up and down is what it's gonna give you.
Okay. What are some other things in the world that might trigger a false positive, like NyQuil? Is that something that would Listerine, like these sorts of things? Can they show up and be kind of a
Well, they're not gonna be a false positive because it's actual alcohol. So
Okay.
it's detecting the alcohol. However, if they were to take Benadryl, and I've been on the stand for this multiple
Right.
times, if they were to take Benadryl or a NyQuil Dayquil, if it were to be taken as directed, as prescribed, it would never even pop up on my radar.
Okay.
However, part of our contract is to not consume, use, or be around any products that contain alcohol so that cannot be listed as a
Okay,
false positive.
so just more of my own education because I obviously deal with this a lot and with the DUI world. What are some things that are on the list that that I am not thinking of?
Body wash.
Body wash.
Body wash has a high content of alcohol.
Okay,
However, it's also going to show me a spike. It's not, you know, all of these products that contain alcohol that we tell them to avoid are just so that they can't use it as a crutch. It's not going to detect it as a consumption because it won't meet the criteria.
what if you took a bath and like soaked in a tub for a minute?
Well, then you're gonna owe me $1,500 for the device because you're not supposed to submerge the device underwater because there's a pump inside of it that takes the air sample.
So no swimming, no
swimming, no
lake days,
baths,
no nothing.
No hot tubs, no saunas, no tanning beds, nothing. They can take showers, they can wash it and dry it thoroughly. We recommend bar soap. If they want to wear body spray or smell good, spray it on your clothes, then put your clothes on. Again, it's gonna dry almost instantaneously on your skin.
Okay, what's something else other than body wash?
We tell them to avoid mouthwash. We tell them to avoid any products that contain alcohol. We also advise them not to utilize any products. Non-alcoholic products still contain alcohol.
So if you were gonna have an NA beer, that's no good too.
No, sir.
Okay. So this number that gets spits out that has from a positive or whatever words you used, what does that number look like? Is there any correlation to beers? Can you
It's kind of like correlating it.
like 20 beers would be like 1,000 or
Well, it depends on how you metabolize it.
okay.
Because, you know, I could be a hardcore drinker and metabolize, even being a smaller person, and
Right.
metabolize it better than a large person that only drinks one or two. So it really just depends on how their body metabolizes it. So I can't tell you what kind of alcohol they were drinking. I can't tell you, know, how much they drank, but I can tell you how their body absorbed it and eliminated it.
What kind of numbers are we talking about in this situation? Just on the court date. Give me the court date one.
So because it's a multi-day, I have it through all the days. On the 10th, it looks like he was between a 0.2 and a 0.4 at one point.
Okay,
Which is high because we start detecting alcohol at 0.02 when it comes to our transdermal alcohol content, our TAC. It looks like he got to a peak of 0.437 on March 5th. March 11th, he peaked at 0.165.
if you were drinking NA beers, is it possible to get a number like that?
I would
You'd have
highly doubt it. I can't confirm one way or the other, but I would highly doubt that.
You'd have to drink like 30 NA beers.
A lot.
Okay. Yep, those are my questions.
Any redirect?
No, Your Honor.
Based on your experience and your understanding of how this works and so forth, any question but that these alerts that you've received indicate that the defendant was in fact consuming alcohol during that time, in your opinion?
Yes, sir, according to our results and our reports. Yes, sir.
All right, thank you.
No questions, Your Honor.
Thank you. You may sit down.
That would be the state's proof on the motion to revoke, Your Honor.
State has moved. You had also, as attached to your motion to revoke bond, attached a copy of the affidavit on his second case, which was committed on the day after he was released on bond on the first one. First case, the one that docket number 19585, that one was committed allegedly on August the 7th. The affidavit, and you have attached the affidavit of the violation of the order granting bail on 8/8/2025. You've attached that as a part of your motion to revoke bond.
Yes, Your Honor. Both of those warrants are included in the indictments that I had listed on the motion.
All right, state has rested their proof on this motion to revoke bond, Mr. Bond.
I would call Mr. Richardson.
Mr. Richardson, come around.
Careful with that chair.
I'm going to remind you that we're going to place you under oath. Raise your right hand and be placed under oath.
Do you solemnly swear affirm testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Okay. Would you state and spell your last name for the record?
Richardson, Richardson.
Okay, Mr. Richardson. So you have heard the testimony from the transdermal company, and on my count, around 28 violations is what I counted. Tell me how that can be so. And also remember, please don't say anything about the pending case that you've got. We're just talking about the transdermal, nothing about the case. But help me and the court understand what happens pretty much the entire month of February and March.
Okay, so the company Nationwide Monitoring is subcontracted out to different individuals in the area. When I got it put on in December, I was unaware or not told that you couldn't wear a sock or any garment underneath it at all. Also,
and that's your for the tampering portion.
Yes.
Okay.
Yes. In the month of January, there's a base unit that comes with the device as well.
Okay.
In the month of January, I would look at the base device and it would say connecting to network, but it would never connect to the server. So I called the company and asked, what is going on? So they said, have you been sent a gray cord? And I said, no, I wasn't given a gray cord when I got it put on in December.
Okay.
Which the gray cord ended up being just a LAN. They sent me one in the mail. It was just a phone line, which you don't even need.
Okay.
In anyway. So then I called back a week or so later because it was still not connecting to the server at all. There was no reading at all that was happening. And I asked if I could go visit my grandmother who lives outside of Knoxville. And upon researching the base unit, because you have to take it with you because you have to be in the vicinity of the base unit once a day for it to upload the readings. So she notified me that I wasn't even registered to the device at all for the entire time from when I had it put on until that she told me that.
Okay.
So then one of the subcontractor workers reached out to me and asked me to meet them somewhere so that they could register it to me. Then we had the snowstorm, so I couldn't get out and go meet them. So eventually my mother had to take me to meet somebody in Fairview and to have it registered to me. Okay. At that time, when she hooked it up, it said for her to do maintenance, and I got a whole new ankle monitor put on. Okay. That was around the time at the beginning of February.
Okay. So tell me, okay.
Yes. So if I'm guilty of anything, the alcohol that I had consumed was 0.0% alcohol. That's not non-alcoholic.
You're talking
right?
about NA beers.
Yes. Well, it's not, it doesn't say non-alcoholic on it, just says 0.0.
Okay.
The monitor reads in the 100th percentile, like she said, 0.02.
Okay.
Now, under my assumption, I thought they were NA, but when you put two and two together, it doesn't seem like it's actually non-alcoholic.
Okay.
There's probably some in the 100th percentile of it, which the monitor would read.
Okay.
In my opinion.
Okay. All right.
And that's all I've drank. I'm diabetic, and I have chronic pancreatitis. The last time I drank heavy, I was in the hospital for 6 days at the VA.
Okay.
So,
all right, I'll pass one to Judge.
Sylvia, you may cross examine.
So when was the last time you drank alcohol?
the last time I drank alcohol was in August.
Okay. And you said when you drink heavy, do you drink at all? You said the last time you drank heavy, you ended up in the hospital.
Right.
Okay. So
No, I haven't drank since August.
no alcohol at all since August.
Well, the 0.0% beers.
Okay. So so your testimony is from December to January, when we got no readings and no violations, your monitor wasn't working.
It was not registered to me at all.
Okay.
Whether it was still vibrating on my leg, but I don't know if it was being, I don't know much about the monitor at all. I just know that what they told me that it was not registered to me.
Okay. So, but it was vibrating?
Yes.
When do you feel the vibrations?
Every 30 minutes.
Every 30 minutes. So
Yep.
it's testing every 30 minutes.
Yep.
Okay.
Yes.
So that all is true.
Yes.
Okay. So how many NA beers did you consume in one sitting?
Well, I would go through 6 to 12 in a day or so.
6 to 12 in a day or so.
Mhm.
All right. And you did that all through January?
No, February.
Okay. So you didn't drink any of those at all in January?
No.
Why in February did you start consuming all these NA beers?
I started going to, when I got released in December, and I started going to be social.
Okay. So you were driving around during this time frame?
No, no,
Okay. So how were you being social?
in my neighborhood.
Okay. So you were just walking around in your neighborhood?
Yes.
All right. So all of these people that saw you drinking would know you were drinking NA beers?
Yes, that is correct.
And your family members would all say, he's not drinking anything but NA beers.
That is correct.
Okay. So you started drinking in February. All of a sudden, where were you getting these during the ice storm?
I wasn't getting them during the ice storm. The ice storm was in January.
No, it was in February.
I don't remember the certain dates that it was.
Okay. So where were you getting the NA
I was
beers?
having them brought to me.
Who was bringing them to you?
My mother.
So when you drank all 12 of those, and what did you do next?
What do you mean? Well, I was at home. I was at home.
Well, we have about a whole month time frame. We have 12 NA beers that you have accounted for. So how were you getting more, and how many were you drinking in a day?
I would go get more. And in a day, like I said, it was between 6 to 12.
Okay, 6 to 12 of these a day.
Mhm.
Where do you go buy them at?
The gas station.
Okay. And what do the cans look like?
What did the what?
What do the cans look like?
They're actually bottles, and there's two different types at the gas station I went to would sell. They're Heineken and Stella Artois.
Okay.
So they're green.
Now, why would you start consuming Heineken and Stella when you are charged with all of these and you know you're supposed to be wearing this monitor?
Because there were 0.0s on the assumption that they didn't have any alcohol in them at all.
Okay.
But when you when you think that it just says 0.0 instead of non-alcoholic, and you put two and two together, it makes sense that it would still have a little alcohol in it. But I was under the assumption that it didn't at the time. But thinking back and putting two and two together, it makes sense that there would still be some in there. And the alcohol monitor reads at 0.02 in the 100th percentile, like she said. So.
And so you were driving yourself to the store during this time frame?
Yes.
Okay. Do you think you have an alcohol problem?
I used to, not since last August, no.
Okay. And the day you miss court, when you have the multi-day consumption, tell me what was going on during that time frame.
I'm actually, so I'm diabetic, and I actually, that day I could not feel my feet. I couldn't feel the pedals when I did try to drive to court. I have neuropathy in my feet. I called that morning and asked to reschedule because I couldn't feel my feet. She said, well, sir, you need to try to find somebody to bring you in. My mother was already at work and my father is blind. So I was unable to get a ride. The next morning on the 11th, when I was able to get out and regain some feeling in my feet, I drove myself to the VA emergency room. That afternoon, while I was at the emergency room, I called back to the circuit court clerk's office and asked them if there was a KPS issued for me, and she said yes. And I asked if they needed to see any medical documents confirming my neuropathy in my feet so that I could try to get the judge to rescind the warrant. I sent over the emergency room paperwork to Holly, and she said that she sent it over to the judge and she would let me know what he decided. That was on Wednesday afternoon. The court date was on Tuesday. So on Thursday, I never heard anything back from her. So on Friday morning, I actually went and got my monitor maintenance on Friday morning in Clarksville at the subcontractor there. And while I was in the parking lot of the subcontractor after I got it maintenance, I emailed Holly and asked if she had heard anything back from the judge. And by the time that she had responded back, I had been apprehended.
Okay. So how many NA beers did you consume during that time frame?
It would have been after the fact. So it would have been after the fact of that morning. So I mean, it wouldn't have been during the time that I would have been needed to be at court, like I said.
Okay, so the testimony that you had a multi-day that included the time frame in which you tested positive for consumption, that's just inaccurate?
No, I wouldn't say it was inaccurate. I didn't say that I did not drink. I said it would have been after, later on in that day.
Okay, so how many did you consume during that time frame?
I would still stick with the 6 to 12.
6 to 12.
Mm-hmm.
You could get out to go get NA beer, but you couldn't get to court?
Like I said, it would have been when I regained feeling in my feet the next day.
Now, did they test you for alcohol at the VA? When you went to the hospital, to the ER? Okay. Did they take blood?
They did.
Okay. I have no other questions, Your Honor.
Okay. Why do you drink non-alcoholic beer?
When?
Why?
Why?
Yeah, why?
I actually enjoyed the taste of it.
So you enjoyed it enough to drink 12 in one day?
Like I said, I was being social some of the time. Some of the time I just, it was something to drink other than water. But I can't.
You've heard the number of days that you tested positive according to this device for having consumed alcohol. And is it your testimony that on each one of those days you drank 6 to 12 non-alcoholic beers?
Yes, Your Honor.
Okay, step down.
I have no other questions, Your Honor.
Anything else, Mr. Ball?
No, sir. That's the bill.
You have any proof?
That would be the rest, that would be closing my proof.
When I was practicing law and I'd have a client who took a stand and told a story that was highly unbelievable in front of Judge Robert Birch. Judge Robert Birch would always say, look outside and see if you see the turnip truck that you think I fell off of. That was his way of basically saying that, the story you're telling is not believable. And unfortunately, Mr. Richardson falls into that category. I do not believe that he drank 6 to 12 non-alcoholic beers in each of these days that this monitor tested positive for consumption of alcohol, and that is his excuse. Even if it is, it's still violating his conditions of his bond by drinking substance that he knows has alcohol in it. But it is this court's opinion that the state has proven a basis for the revocation of his bond for violation of the conditions under the statute, and therefore his bond is revoked. We are at recess for lunch until 1 o'clock, when we're going to take the plea on the vehicular homicide case with the victim impact statement. Following that, we're going to be dealing with the side case involving the animal rescue and the cyber.
All right.
All right, we're here on the State versus Wyatt E. Lester.
Judge, we have a disposition, the paperwork is
All right, I've
on
been
the
handed
bench.
the disposition.
Come up, Mr.
What I've been
Lester.
handed indicates that he is going to be entering a plea of guilty to count one, criminally negligent homicide, receive a sentence of 1 to 2 years, Department of Corrections.
Sorry, that's count 1, 2 years.
2 years is a Department of Corrections range 1 offender suspended to probation conditional under 40-35-313. Count 2 is aggravated assault, 2 years Department of Corrections and range 1 suspended to probation conditional under 40-35-313. Those are concurrent with one another. And count 1 is not to operate a commercial vehicle as a condition of his probation.
Judge Stephen Young is here. He's co-counsel, and I may have to leave at some
That's
point.
fine. All right, let's have Mr. Lester raise his right hand and be placed under oath.
Yes.
Thank you. Step up in front of that microphone and state your full legal name.
Wyatt Emery Lester.
Mr. Lester, you're here today on a 6-count indictment. You've heard me go over what the agreement is as to 2 of those counts. The remaining counts are to be dismissed as a part of this agreement. But have you seen or been shown a copy of those charges? Talked them over with Mr. Flanagan. You and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty to these 2 charges and have the rest be dismissed. Do you understand you have a right to plead not guilty to all charges and have a speedy and public trial by jury?
Yes, Your Honor.
You understand that at trial you would have the right to have a lawyer and to have one appointed for you if you cannot afford your own?
Yes, Your Honor.
You understand if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that you and your lawyer could confront and cross-examine every witness that the state called at trial, and you could bring in your own witnesses by the use of a subpoena.
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal if necessary.
Yes, Your Honor.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what the state and your lawyer have reached an agreement about.
Yes, Your Honor.
You understand that's going to be under 40-35-313 because you have no prior criminal record. The state has agreed that you would be eligible for this program. What that means is that you're going to be on probation for a period of 2 years, and you're handing me these guilty pleas, and they're going to be in your file for 2 years. If you stay out of trouble and complete all of the requirements and don't violate your probation, at the end of that 2 years, you have the right to come in and ask for your record to be expunged. It will not happen automatically. You'll have to seek that to be done. But on the other hand, if you violate your probation, then you can be brought back before this court and you can be resentenced within the range for the offenses that you are entering this plea to. Do you understand that?
Yes,
In other
Your
words,
Honor.
you could get more than 2 years if we have to resentence you. Secondly, those would become permanent convictions on your record and would be there in the future to make more severe the punishment you receive if you're ever again convicted of a crime. Do you understand all of those things?
Yes, Your Honor.
You still wish to enter a plea according to this agreement?
Yes.
Do you understand if you plead guilty, the court of the state could ask you questions about this offense? And if you answer those questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
Do you understand I cannot accept your plea unless I'm satisfied that you are in fact guilty and that there are facts to support that finding?
Yes.
Then I will ask you, are you guilty of this charge of criminally negligent homicide?
Yes.
And are you guilty of the aggravated assault by reckless conduct?
Yes.
State want to lay a foundation for this factually.
We'll let the DA get it.
Your Honor, on August 11th, 2023, at about 7:49 in the morning,
Mr. Lester was operating a FedEx box truck eastbound on I-40 near the 186 mile marker here in Cheatham County. He was approaching stopped traffic on I-40. Everybody was stopping, and he failed to exercise the standard caution, look ahead, safety and care that would be reasonably expected of a person, because all of the traffic was stopping and Mr. Lester did not stop until 0.4 of a second prior to striking the vehicle being occupied, being driven by Gerald and Latanya Kaiser. When he struck that vehicle, he injured Mr. Kaiser, and he caused the death of Latanya Kaiser. That is the basis of the criminally negligent homicide against Latanya and the basis of the aggravated assault against Mr. Kaiser. Now, the remaining counts that have been nollied in settlement are in essence, the result of this sort of ping-ponging action of other vehicles on the road that followed that collision. But that is the factual basis, Your Honor.
All right, Mr. Lester, if you'll come back to the podium. I am not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, Your Honor.
Are you satisfied with your attorney's services?
Yes,
You feel that Mr. Flanagan has done a good job of representing you competently?
an amazing job, Your Honor.
Mr. Flanagan, do you know of any reason you should not enter this plea?
No, Your Honor.
Anything further from the state? I believe you have victim impact statements.
That's correct, Your Honor. I've got 3 statements, I believe, from the witness.
All right, then let's have Mr. Lester have a seat at the table there. If Mr. Flanagan is required to leave at that point, at some point, then we'll go ahead and allow his co-counsel to sit in for that.
Hi to you. Yes, thank you. I am Nadia Ross, the daughter of Latanya Gazard. I hate to be here today, but I speak for my mother, for my father-in-law, and for my brother who was with her. This is pretty hard for us. I lost the matriarch of my family. I miss her so much. And in 2023, my life changed before me. I have never been the same. I don't know what to do without my mother. Her granddaughter, her grandkids doesn't know what to do without her. But I just say to you, sir, you took so much away from me. Everything I learned, every woman that I tried to be and teach my child to be, you took her away from me. And that's all I have to say, Judge, and I thank you.
Thank you.
Good afternoon. How y'all doing? I'm the oldest of Latanya, the stepson of Garland, and also I was a passenger in the vehicle that day. Sustained injuries and had to go to Vanderbilt and things like that. But I want to talk to y'all about my mom. I'm here to honor her today. She was the 4th of 6 kids. She was born to Rosalie and Eugene Ford. She was a loving mother to me and my sister. She was a proud grandparent and a devoted wife to Garland. She was a woman of guidance and leadership, loved and respected by many. A God-fearing woman, a straightforward woman, the kind of woman that would tell you the truth, whether you was ready to hear it or not. I miss her. miss her deeply. I find peace in knowing that God plucks from his garden and he replants with purpose. What's taken today will blossom tomorrow in eternal life. Today I stand here before you with many titles. As a son that lost his mother, as someone who's experienced loss and grief, as a victim, as I say, I was in an accident as well. But most importantly, a Christian man. And because of my faith, I stand on my foundation of grace. I won't deny the pain. I won't ignore the loss, but I choose something better and I choose forgiveness. Doesn't mean that the loss is forgotten. It doesn't mean that the pain is gone. I just choose not to let it have the final word. To you, you caused my family a tremendous, unimaginable amount of pain, but I acknowledge that you've taken responsibility for your actions. For the sake of my own peace, I choose to forgive you. Not because it's easy, but because it's right. And that's what my mom would want. Ephesians 4:32, it says, be kind to one another, be tenderhearted, forgiving to one another, and forgive just as Christ forgave us. So I'm gonna live by that standard. So today I release what I can no longer carry and I put it in God's hands. And I pray for you.
Thank you. Mr. Arnold?
To the court. I would like to just start with what the kids said about their mom and my wife. It's just a very small part of the woman that she is. She was a woman that is unexplainable. And I'm pretty sure every husband feels the same about their wife and their spouse. But I can say, yeah, man, you broke me. You broke me. I've always been a provider, someone strong for my wife and the kids. I've done a lot of things in my life. And I always felt that with God, I couldn't be broken. This broke me. This is what you took from me. I can never get that smile back, no matter how hard I try. This doesn't come back. But Tanya was a wife and a woman that is unexplainable in words. I just can't say she was there. Outside of God, she was my world. And I could say I've been broken. I look at this picture and I'll never get this smile back. I never get this back. This young man turned me to a liar to people that I'm around. Because people ask me, am I okay? I'm not okay. A lot of people tell me I'm okay. I'll be all right, but I'm not. The final things of her life, I never got to do it with her. I penalized my wife a week out of the hospital. I wasn't there to give her the proper farewell that she deserved because of my injuries. Her last birthday together, 2 months later, took her away from me. I never questioned God, but your actions I question. It's not God, I question your actions. And your actions caused this. Not God. Your action caused this. You can't compare a speech for someone that you love the most and miss the world of. I have a speech. I just have distant memories. Long distant memories. And the question that I do have for you, I was listening to the judge's statement. Is he a convicted felon?
For 2 years if he does everything right. If he does anything wrong, then yes.
Because
If he completes the 2 years of probation and doesn't make any mistakes, then he will be able to apply to have that come off of his record.
she's gonna fail.
You're right, she is.
That's all I have. Thank you, y'all. Thank the court.
Mr. Arnold, anything else?
That's from the state level.
All right, Mr. Lester, if you'll come back to the podium. Mr. Lester, upon your plea of guilty to count 1, I find that you should be placed on probation for a period of 2 years with the Department of Corrections as a range 1 offender. In count 2, you'll be also sentenced to 2 years probation as a range 1 offender. Those are both offered or entered rather under 4035-313. And under count 1, the agreement is that you will not operate a motor vehicle, a commercial vehicle, as a condition of your probation. Counts 3 and 6 are dismissed as a part of the agreement. I don't know all of the facts other than the fact that all of us who travel on the interstate day and night and are driving motor vehicles, and then we come upon or a 18-wheeler comes up on top of us, it's a scary situation to occur. And whatever the situation was that caused this, my understanding on the only reason I've accepted it is that there was no drugs or alcohol in Mr. Lester's system at the time, and this is purely a case of negligence on his part, if I understand correctly. And so it's for that reason that this agreement was entered. But Mr. Lester, you understand that you must abide by all of the conditions of this probation.
Yes, Your Honor.
To the family, I would simply say that there's nothing that I can say or do in this case that's going to make the pain that you feel any easier. Any of us who have lost our mother in the past know what that pain feels like. Yours is just unfortunate because, and it's tragic because of how severe and sudden it was. And when you lose a parent or your mother especially, a part of you seems to be taken away as well. Hopefully with time, you can keep those loving memories that you have of her, like that photograph that you showed us, keep those alive in your heart, and you'll keep her alive in your heart, and some of the pain will ease. To the extent that this court can aid or assist you, I've done what I can do in putting these conditions on. That will be the judgment of the court. Mr. Lester, you need to see the probation department. Mr. Arnold, you have not signed off on that pretrial judicial diversion. What? Defendant is coming out of the district attorney general for the state and defendant counsel for entry of judgment. Try that one. That look like it would be the right one. Yeah, I know you're out of practice. That's good. He would like to bring it up here and show it. He wants to come up here and show it. This is what was not shown very clearly was the photograph that you were showing of other people in court. And I wanted you to have an opportunity because this court live streams much of what I do. I live stream where it's permissible. So there is going to be a video of this event that will be online on YouTube, and you can watch that when you get home. And I wanted to give you an opportunity to demonstrate this picture of your wife to show the people when out there in the world what she appeared to be and what she was. So, and if you will hand that to Mr. Arnold, I will give you a closer look. So here we go. And was she on a motorcycle? Did she have a motorcycle?
Oh, no, sir.
It looks like that there was a motorcycle behind that. Or I guess that's her birthday, isn't it?
Yeah, that's her birthday.
Okay. All right. Well, I wanted everyone in the world to be able to see your beautiful wife and to know what you've lost. So, all right. Thank you. You may. All right. We are now ready on. Rebecca, State of Tennessee versus Rebecca Sipes. Docket number 2026 CR 19854.
Judge,
Your Honor, sorry. We were gonna let Mr. Willoughby's case go real quick. It should only be a few.
What case is that? I thought we-
Austin Simpkins, Your Honor.
Who?
Austin Simpkins. It's on the 1 o'clock portion of the docket. Yeah, well.
All right, so what is this, again, what is this for?
Your Honor, I filed a motion to amend the bond conditions to allow supervised visitation for his minor children if approved by the juvenile court, because right now his bond conditions prohibit any contact period with any sort of minors. And this was set today for a hearing, and I have one witness for the court to hear. And I also filed a request for bill of particulars, but I think that's not being contested.
No, we're.
So has the juvenile court entered an order that would allow him to have visitation?
The juvenile court right now, the order only allows his mother custody and visitation. And I think that's because when he was arrested on this, the bond conditions prohibit him from having any sort of contact. So I would say that the juvenile court, that the custody arrangement was created after he had posted bond with the bond conditions. And so what we would be asking for, I just have one witness, is just to amend those bond conditions to allow it if the juvenile court sees fit to do so. If they decline to give him any sort of supervised visitation, then we would be in the exact same position right now.
Well, your client is charged with a Class A misdemeanor in count 1, and count 2 is charged with a Class A felony.
Yes, Your Honor.
And Class E felony in count 3, and count 4, Class B felony. My concern is that you're asking me to put an order down that would allow supervised visitation without any other kind of evidence or anything else, or any indication that the juvenile court is going to allow it. I understand you're saying subject to the juvenile court. Visitation and contact with the children is always going to be supervised by the juvenile court, but the juvenile court doesn't have jurisdiction over these Class A felony charge.
Yes, sir. And that's
My suggestion would be that when the juvenile court enters an order, I will put an order down that says that we will defer to the juvenile court to allow them to decide whether it's in the best interest of these minor children that your client have supervised visitation. And upon that, then you can revisit the issue with either me or one of the other judges that would allow, and I'm sure if the juvenile court says it's in the best interest of the children, then that may be pro forma for us to sign off on it. But I'm hesitant to put an order down in advance of the juvenile court making a finding that would allow that. And I understand you're asking for it to be subject to the juvenile court's order. But I don't want to infer to the juvenile court that I agree that the children ought to be allowed to have unsupervised contact with this man. If he's convicted of the Class A felony, he will be going to prison, obviously.
Yes.
He's presumed to be innocent. But so my suggestion would be get the juvenile court to let you know if they're going to agree to that, and then just let them know, as we've done in many other cases, that you can get an agreed order signed off on by the DA, and unless the DA opposes it.
The state's position is we're going to oppose any modification of that bond condition because of the nature of the conduct involved until the conclusion of this case. But I agree with you. We're kind of getting the cart before the horse.
It seems to be premature for this court to be asked to do it when the juvenile court hasn't said that they would even agree to it. So
I guess the only reason I file it is because this court explicitly prohibits any contact with any juveniles, and I think that's what the juvenile court would also consider. So I just didn't want him to be in a situation of, I wanted to get this amended first, and then it would be obviously subject to the juvenile.
well, we have a judge here every month. So is this a case that I have to hear?
I know Judge Turnbow is conflicted.
And I know Your Honor took the plea for the, I'm gonna use the term co-defendant, even though she's not technically a co-defendant for Ms. Shannon Elliott. So Your Honor is the most
All right,
familiar.
well, here's what we'll do. I'm in court somewhere every month, and I have criminal dockets every month. If the juvenile court indicates that they're willing to consider a supervised visitation schedule, then you can contact my office and we will schedule you a hearing wherever I am. Mr. Willoughby's good about traveling. He has fishing holes all over the 23rd Judicial District he likes to visit. So we'll let you refile your, or ask for your motion to be heard. I'm just deferring the motion because I don't think that it's appropriate for me to put an order down approving unsupervised or supervised contact with the children where the juvenile court hasn't done that. But I also want to give the state an opportunity to explain why they would oppose even supervised visitation.
Yes.
But it may all be academic if the juvenile court's not going to allow it anyway.
So Your Honor prefers wants the juvenile court to move first.
I prefer juvenile court to make a ruling on it first, and then only if they agree or if Judge Maxey says that in his opinion, supervised visitation would be appropriate, then we'll give the state an opportunity to be heard as well. So. All right.
Thank you, Your Honor.
Thank you. I'm sorry. What is the status day right now? It'd have to be July, wouldn't it?
I don't know if we set one in July. I think we were just tracking it today.
Are you scheduled to be in front of the juvenile judge anytime in the foreseeable future?
No, Your Honor, I'm gonna have to speak with my client about that.
Your Honor, there's like 3 months of almost 8 hours a day videos that Mr. Pugh now has, but we had it.
Is this the co-defendant to the woman that we had to enter the plea some time ago where the young boy was killed?
Was beaten to death, yes.
Beaten to death, and your office read a detailed
yes,
day
Your
by
Honor.
day.
Myself and
description of
General
what that
Sagi.
video show. All right.
What we were talking about because of the volume of digital evidence is a November 10th to see if Mr. Pugh has been able to, because like I said, we had a whole team of TBI that sped that up because they could divide and conquer. So if that's a suitable date for Your Honor for a status to see where we are. And then I think to put on the record, he did file a bill of particulars, but we're going to discuss that and try to get that remedied between us.
So is July 14th the day that you're talking about, or a different day?
I was talking about November 10th.
November 10th?
Yes, sir.
All right, November the 10th will be the status for it. So.
Thank you, Your Honor.
All right, in the matter of the state of Tennessee versus Rebecca K. Site.
Judge, I represent the site. there's several things that are kind of pending. The first of which is this odd civil criminal piece of the law that requires effectively a restitution hearing on the front end. That I'm not prepared to go forward with because I got all of the financial information for this cash bond yesterday at 5. They're asking for a significant amount of Miss Sipes money. I feel like I should have a little longer than a day to prepare for that. I would have said this even if I'd only had 20. I understand that the Byrd attorney is wanting this done and has wanted this to be done for 7 months. And, you know, sorry about that. I had nothing to do with any of this. But yeah, I would like another date to actually review the topic with which we're going to be discussing. So that'd be the first order of business today. I don't believe the state's opposed to that.
Your Honor, it was my assumption that when we turned over all the discovery had been included in that, which was done directly after the arraignment. When I sent just a reminder email yesterday to Mr. Vaughn, he had made me aware that that was the first time he had seen the financial documents.
Well, this is a case of first instance for this court at least. And we've had a prior court hearing in which it was brought to my attention what was taking place. In the General Sessions Court, the General Sessions judge consolidated, put an order down consolidating the petition filed by the Animal Rescue Corporation, also known as ARC or ARC, seeking to have they have actual physical custody of the animals that were removed, and they have filed pursuant to statute to try to have a bond set by Ms. Sipes. If she intends to try to recover these animals, then she's going to have to pay for the cost of their upkeep, because right now that cost is being paid for by the Animal Rescue Corporation, Animal Rescue Corps. And under statute, they have a right to ask for a bond to be set to secure the cost of those upkeep of those animals. And if she's not able to do it by statute, then the animals would be surrendered, deemed to be surrendered, and would be allowed for Animal Rescue Corp to put them up for adoption, so that the cost of care for those animals is no longer being paid out of pocket by Animal Rescue Corps. It is an anomaly, so to speak, in that the state statute that Animal Rescue Corps is operating under allows them to intervene in a criminal case, even though they're a civil group, for the benefit of the minor children, the animals that were in question. So what is taking place right now is two things. I have the issue of we set this specifically for the bond issue to be heard so that Animal Rescue could deal with the cost of providing care for the animals. And then the other was your client has filed a pro se motion for supervised visitation and preservation of evidence, in which she is seeking to have supervised visitation with the 17 animals that were removed from her care and custody. So how long of a period and exactly why is it necessary for you to, number one, you were appointed to represent her on the criminal case. And correct. So it's unclear to this court. And I know we had this discussion the last time about whether or not you had any standing to represent her on the civil part, except for the fact that the two have been consolidated.
Right. And I know that I'm still, I'm still confused as to the line for my exposure as my duties as a public defender and, you know, is this, I mean, do I need to go get malpractice insurance for this? Like, you know, I would like a little more time to get familiar with this whole situation. I can hear the bird visit motion today. I'm down. I'm perfectly okay with that, but the rest of the stuff, I have no idea. It's fresh.
Well, you were appointed to represent Ms. Sipe on the criminal charge. And in my opinion, you have no obligation or duty as the public defender to represent her in the civil action that runs corollary or is correlated with it. In other words, if we have to have a hearing on her request for visitation or on the ARC's request for a bond to be posted, then I don't think that you have to be involved in that because of the simple fact. I mean, I know we've had discussions about this previously,
right?
But I agree with you. It does seem to me to pose a question as to whether or not you as a criminal lawyer have any duty or obligation towards your client in the civil portion of this case. I mean, have you consulted with Mr. Mitchell about this scenario?
We've talked about it in the regard of just the facts and circumstances of the case, and he's as confused as anybody is about this bird stuff, Judge, to be honest.
Well, let me hear from the ARC's representatives, if you will. And Mr. Huddle, I'm going to give you an opportunity to be heard as well.
Good afternoon, Your Honor. Jessica Schultz here on behalf of Animal Rescue Corps. We can refer to them as ARC for short. I appreciate your willingness to expedite this, to have this hearing today. A few things of response to Mr. Vaughn is that in the general sessions case, we were subpoenaed for production of documentation and that was early January of this year, of which we did provide all of the invoices and receipts for discovery at that time. Since the arraignment in this case has proceeded, I've not received any motions for discovery for my information. However, I did turn it all over to the state for them to have access to put in their file as well. So with that, back in January, when we did give Ms. Sipe's attorney at that time, the General Sessions Court did appoint her an attorney in our case as well. And she had asked for a 3-week continuance to review our receipts and records at that time, which we did agree to, knowing that the defense knows every day that goes by, the costs are increasing, which that's part of their argument, is that the costs are too high. Today, we stand at 237 days we've had to take care of these animals, 17 in total. It is not cheap. And additionally, Ms. Sipe was aware of our daily costs back in September. And again, there has been numerous requests for continuances on the defense side. ARC has not caused any delay in this. Secondarily, there has been a lot of confusion regarding whether this case is civil or criminal, etc. The last time we were here, I did reference State versus Tilley, which is a Court of Appeals opinion that does interpret this statute. They interpret this statute as this is a criminal matter. So with that, again, it's very clear as far as the opinion that this is not civil. This is not a civil matter, although we do see where the confusion lies in us being a third-party petitioner in a criminal case that is unique, which also this case is unique. So that is part of why we, we're running into some of this confusion. And so we believe that the Court of Appeals has made it clear that this is part of the criminal case. And it is not my, opinion to say whether his representation extends to that, as far as what his scope of representation is for Ms. Sipe.
Well, let me interrupt you and ask you,
Yes.
Do you have a copy of that decision, of that appellate court decision?
I do.
All right, go ahead, I interrupted you.
So we are able today, we have all of our witnesses. We're able to put on all of the proof, and we are able also to provide them any documentation that's requested that, again, we believe they've had access to.
What, if you don't mind stating for the record, what is the Animal Rescue Corps asking for in the way of a bond under that statute?
Yes, so at this point, we are asking for all expenses, boarding and medical services that have been rendered to these animals in the last 237 days. We're asking for an order today to be issued for our incurred expenses to date. And then it's the judge's discretion as far as how you wish to fund the expenses as her criminal case continues, because the statute's clear that this bond is to cover until the disposition of her criminal case.
So are you asking for a judgment against Ms. Stipe for those funds? Or that have already been expended, or are you asking for a bond to ensure payment? Because under the criminal law, she's presumed to be innocent of these charges, and we have to balance that with ordering her to pay some amount out of her pocket. Now, that's different than posting a bond to secure the cost of the animals. And if we don't, if she's, let's say I set a bond of $250,000, just picking something out of the thin air to secure the cost, and that's the amount of the bond she would have to provide. And she can't do that. She's got an appointed attorney because she is found to be indigent. Then what happens to the animals then, so that Ms. Stipe understands and the record is clear, what would be under that statute the next step?
Sure. So regarding, I believe, State versus Tilley addresses that this is a security bond order to cover the cost. And it is a pre-trial matter. So it's before her criminal case is decided. And therefore, the statute also addresses that failure to pay the bond within 10 business days would deem her to have abandoned the animals, as she has a financial duty to care for these animals, regardless of if she has custody or not. This is the way the statute reads, that then the animals would be abandoned by her, and they would then be forfeited to the responding agency, which Cheatham County Animal Control and ARC have worked out that ARC would be deemed the owner since they've incurred the expenses to date.
All right. Let me hear from the state to see whether Mr. Hodlin has anything to add. So,
Your Honor, I think if we follow the case law here and call it criminal, I may have some of the similar concerns that Mr. Vaughn had about the extension of our practice and or external attorneys. I'm unclear if it is criminal outside of a special prosecutor for victims where I can have outside counsel assisting the state.
Well, let me,
hearing.
I'm going to take a recess and read this case, and that will assist me in determining what exactly the status of it is, what Mr. Vaughn's position is regarding this case, as well as what your office's obligations are. But clearly, this is a state statute that was adopted by our legislature, and therefore it has to be followed, absent some finding it's unconstitutional. Now, another question is exactly what are we talking about as far as the financials that you say you've not been able to review, Mr. Vaughn?
7 months worth of keeping 14 animals being more than $240,000. It seems criminal. If we're talking about criminal civil, that sounds criminal.
Well, that figure is maybe what I picked out of the air.
No, that's what she said.
Your Honor,
That is not what I said, Your Honor.
It's boarding costs, it's veterinary care, it's food, it's feed, it's medicine, it's basic standard costs for the animals. For my review of the material, there's very little, if any, surplus in there. It's their toys for enrichment purposes, it's food, it's medicine, it's veterinary care, and it's boarding costs.
All right. I'm going to take recess, read this case, come back, and I'll tell you what we're doing today and what we're not. So.
All right.
All right, we're back on the record in the state versus SIPE, and I would like to make a couple of observations on the record. First and foremost is this is a statute that has not been litigated to any great extent, so that we have a pattern of jurisprudence for this court to rely upon as far as the roles of the various parties. In this case, the state initiated criminal action against the defendant, Ms. Sipe, in this case, charging her with cruelty to animals. The prior to the actual criminal charges being brought, I think there was a removal of 17 animals, if I understand correctly, the number from her, from the defendant's possession, alleging that those animals were not being properly cared for. As a result of that, she is charged in the indictment with a crime of cruelty to animals. And now what we have is that the Animal Rescue Corps, which is the group that removed that, has come in under the statute that allows them to bring an action and consolidate that action with the criminal action, which is put the situation here where the Animal Rescue Corps has had these animals in their possession since August, and they are asking for a bond to be posted by the defendant under the statute, which says that they are required to post a bond to provide for the care of the animals that were removed, and that they she must post that bond within a statutory period of 10 days. And if she fails to do so, then the animals would be considered to be forfeited. By contrast, now Ms. Sipe, who has been found by the court to be indigent, has a court appointed public defender representing her. And part of the problem with that is that Mr. Vaughn with the public defender's office has struggled, rightfully so, with the question of what exactly is his role. He represents her on the criminal charges, but this is a procedure that is it's not exactly part of the criminal case, but it is consolidated with the criminal case. And the Animal Rescue Corps has cited the case of the state of Tennessee versus Carolyn Tilley Lee, which is a court of civil appeals opinion issued back in 2016, so that it's clear, and I state this for the Court of Appeals and Court of Criminal Appeals, as far as I can tell, there was a disagreement between those two august bodies as to who exactly had jurisdiction over these matters. The Court of Civil Appeals said, oh no, this is not a criminal matter, this is a civil matter. When the person, in that case, there were 3 horses that were seized. The notice was given that the owner of the horses had to file a bond, and within 10 days, and they appealed it. The Court of Civil Appeals is where they filed their appeal because they considered it to be civil in nature. The Court of Civil Appeals says, no, it's criminal in nature. So they ordered it transferred to the Court of Criminal Appeals for the state of Tennessee. The Court of Criminal Appeals looked at it and said, no, this is civil in nature because it's like a forfeiture, and those are forfeitures that are civil in nature, so we don't have jurisdiction. So they kicked it back to the Court of Civil Appeals. And guess what? Tennessee Court of Civil Appeals said, no, we don't have jurisdiction either because this is not a forfeiture. This is if the procedure goes forward and the person can't post a bond, it's considered to be an abandonment. We hold that it's a pretrial criminal procedure and is not a civil action. Now, that's the only case that I think all of the lawyers agree has been ruled on. And what does that tell us? It tells us that the 2 appellate bodies, intermediate appellate bodies, disagree as to whether or not this is a criminal or civil matter. For purposes of this hearing, the court is going to follow the Court of Civil Appeals ruling that this is a criminal pretrial procedure and is not a civil procedure, and therefore we're going to go forward this morning or this afternoon and tonight with the hearing on the request for bond that has been filed under the statute by, I think it's Tennessee Code annotated 3914-210 subsection G1A. And that is the provision that governs the requirement of posting a bond by the owner of animals that were seized as a result of animal cruelty. We're going to go forward with that hearing and allow the Animal Rescue Corps to put on their proof regarding the animals and what care they have incurred, costs of care they have incurred, of what they're requesting in the way of a bond. We have also a second motion that has been filed by Ms. Sipe, which is a motion for visitation, supervised visitation and preservation of evidence. And that is for her to argue at the appropriate time. We're going to deal first with the bond issue and let Animal Rescue put on their proof. Then we will go, after we conclude that hearing, we will move to the request for supervised visitation by Ms. Sipe. All right. Then I think under these circumstances, Mr. Hodlin, do you agree that it is Animal Rescue Corps that is the moving party on this particular portion?
On the matter of seeking a hearing for what the judge may determine as to the matter of the bond, and yes, sir.
Correct. Right. In view of that, then we are ready to allow you to put on your proof if you want to call your first witness.
Judge, I'd like to ask for the rule.
The rule has been requested. That means that anyone who's going to be a witness other than the parties must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You're not to discuss the testimony of any other person with anyone until you yourself have testified. Counsel are under a continuing duty to ensure that the rule is complied with. Ms. Schultz, you are, I think, about to call your first witness. Is that correct?
Yes, I'm going to call my first witness as Brittany Sellers.
All right. So any of the other witnesses you intend to call must go outside. So. If you will step up and raise your right hand and be placed under oath, please.
You solemnly swear affirm the testimony you write to the truth, the whole truth, and nothing but the truth. God. I do.
Good afternoon. Can you please state and spell your name for the record?
Brittany Sellers, Brittany Sellers.
Okay. And where are you employed?
Cheatham County Animal Control.
Okay. What is your role there?
I'm the director.
Okay. How long have you been the director?
5 years.
Okay. And what are your duties?
So we handle all animal related cases in Cheatham County. We do criminal complaints for animal cruelty, neglect. We do roaming at larges. We do welfare checks. Any animal related cases we do.
Okay. And do you regularly handle cases involving alleged cruelty and neglect cases?
We do.
Okay. Did your agency respond to an animal welfare concern at 2740 Mossley Ferry Road in Ashland City, Tennessee?
Yes.
Okay. And whom is the owner of that property?
Rebecca Sipe.
Okay. And who is your agency's lead investigator?
That would be myself.
Okay. And did your agency receive a search warrant to search Miss Rebecca Sipe's property?
We did.
Okay. And did you execute that search warrant?
We did.
Did your agency seize any animals upon execution of that search warrant?
We did.
Okay. And whose custody were those animals seized from?
Miss Rebecca Sipe.
How many animals were seized?
17.
Okay. And what type of animals were they?
11 exotic birds, 3 chickens, 2 dogs, and a miniature horse.
Okay. And have criminal
I'm sorry,
charges
could you
been?
repeat that? What were they again?
11 exotic birds, 3 chickens, 2 dogs, and a miniature horse.
All right. Thank you.
Yes, sir.
And have criminal charges been filed?
Yes.
regarding the specific types of animals seized, does your agency have the ability to care for those types of animals?
We do not.
And are you familiar in your role with the laws governing animal seizures subsequently to or specifically Tennessee Code Annotated 3914-210?
We are aware.
Okay. And under that statute, is your agency given the authority to place a designee in your position?
It does.
And what agency or organization was designated to be your designee for these animals?
Animal Rescue Corps.
Okay. All right, I'm going to hand you a document.
Judge, I'm going to object to this. I've never seen this.
What exactly is the document?
More discovery I received 7 to 10 days ago. Your Honor.
What document is it?
Sure, so it is, I will let Ms. Sellers explain, those were my next questions, but it's a request from Ms. Sellers to my client asking them to be their designee.
Right. Well, the document itself would be considered to be hearsay, but the witness can still testify about making the request.
She drafted the letter.
Pardon?
She drafted this letter.
And a statement made outside of the courtroom is still considered to be hearsay if it's being introduced for the truth of the matter asserted in the letter, which is that they're asking for you, Animal Rescue, to be the designee. So that doesn't make it any less hearsay, but even though it's a statement she made. General Hodlin, you have.
Your Honor, it was only all evidence besides apparently financials, unless something new shows up today that I'm unaware of as was released at arraignment. On what, the 15th, 16th? 10th? I mean,
All right, well, here's what we're going to do. I'm going to allow this witness to testify about what steps she took to engage Animal Rescue. That's not hearsay. That is making her, showing that she took certain action. I'm going to allow the introduction of the letter because the letter is, again, being introduced to show why the Cheatham County Animal Control took certain steps, and there's a line of cases that are exceptions to the hearsay rule that allows the introduction of evidence which shows the course of conduct or the reason that a witness took a certain course of conduct. So I'm overruling any objection and allowing the introduction of the letter. So you may proceed.
Thank you. Can you identify that document?
Yes.
Okay. Can you explain what it is?
This is a letter I drafted and emailed to the Animal Rescue Corps asking them to be our designee and basically step in our shoes and handle the care of these animals.
Okay. And is this a letters that you would generally create in the course of requesting a designee?
Yes.
Okay. And is that a true and accurate copy of the request you made?
Yes.
Okay, I would like to move that letter into evidence as a business
Well, I'm going to
record.
allow it to be marked as Exhibit 1 to this hearing.
Thank you. And based on your request, did ARC become your designee?
Yes.
And did they take custody of the animals?
They did.
And was that at the time of seizure?
Yes.
Was that on August 7th, 2025?
Yes.
Okay, thank you. And why did you need ARC assistance?
So our organization has a small shelter in Pegram. We have 26 dog kennels and about 30 cat kennels in our building, in our facility. On any given day, they're full, and we actually have additional kennels that are set up. So we were not capable. It's called capacity of care. Our shelter, our structure, our staff was not capable of handling dogs, let alone exotic birds. We're not set up to handle exotic birds or any type of wildlife.
Okay, thank you. And what was your understanding as far as ARC's responsibility being your designee?
My understanding was that ARC was basically going to stand in our shoes and provide necessary veterinary care, food, sheltering, basic cost of care, daily care for these animals.
And was part of your agreement and included in your request as designee that ARC may make arrangements to place animals with other approved partners if the need arose?
Yes.
Has Cheatham County Animal Control given ARC or anyone involved in this case any money for care of these animals?
Not one penny.
And you understood that ARC was going to file a petition requesting their cost of care be covered under that statute?
Yes.
And what is your understanding of who's responsible for covering the cost of care under that statute?
It's my understanding under the statute that Miss Rebecca Sipe, who's the owner of the animals, is responsible for cost of care. And if it's not provided within 10 days, once the bond is set, if it's not provided within 10 days under the statute, the animals are deemed abandoned and are forfeited to either the animal control agency or our designee, which would be ARC.
Okay. And does your agency have the ability financially to pay for these animals to be boarded in an outside facility?
We do not.
And does your agency have any resources at all to provide medical services for these specific types of animals?
We have a very, very small nonprofit that supports our budget, what we can't afford typically, but it's a very, very small amount of money. It would not care for exotic birds. It would not cover the cost of care for exotic birds.
And if for some reason if ARC decided they no longer wanted to assist you with being your designee, would that responsibility then fall back on your agency?
It would.
Has ARC helped your agency before?
Yes.
Okay. Do you recall how many times?
Once before.
And what were those types of animals?
So we requested their assistance on a call about a month prior to this case. It was what we understood was about 40 to 60 small dogs. It ended up being 113.
And were there any differences between that case and this case as it relates to the security bond being requested?
Yes.
And
The
what
day of the search warrant and seizure for the 113 dogs case that ARC assisted us with, the owner of those animals surrendered the animals on scene. When she surrendered the animals, that allowed ARC to take possession of them legally and get them to appropriate adoption facilities or rescues from there.
Okay. And that leads to my next question. So in the event if the defendant in this case either surrenders or cannot post her bond, what would be your agency's involvement at that point forward?
Can you repeat that question?
Sure. So in the event that ARC, if the defendant surrenders the animals or cannot post the bond, what is your agency's involvement at that point?
We would pursue the criminal charges and go forward with the criminal proceedings.
Okay. And then who would be deemed the legal owner at that time?
ARC.
Okay, no further questions?
Mr. Vaughn, you have questions?
Yeah, just to, Judge.
So I guess to understand this, you entered into a contract with Miss Sipes Animals for these people to own them effectively if Miss Sipe can't pay their bond.
They're our designee, yes.
Okay. Do you think that you have that ability to give away her animals to these people?
It wouldn't be giving them away if they were abandoned and therefore forfeited.
Okay. What do you know about the care of exotic birds?
Not a lot. That's why I considered ARC as our designee, because they have someone who's specializes in aviary care.
Aviary care. What would you ballpark a exotic bird to cost a day?
Depends on the bird. I'd say the cost of care of a bird or to purchase a bird.
Both. What? Give me both numbers.
I would say $1,500 to $2,000 per bird to purchase on the low end.
Judge,
It's cross-examination though. Doesn't matter whether it's outside your direct examination. Overruled.
Carry on, ma'am.
I would say to purchase an exotic bird would be anywhere from $1,500 to $2,000 in my very limited scope of birds.
What about to feed a bird today? What do you think that costs?
Between $100 and $200 a day.
$100 a day to feed a bird? A bag of bird food is.
If they have medical conditions, it's substantial.
Okay. So has Cheatham County Animal Control ever sent Miss Sipe animals to take care of in an overflow situation?
We never sent them to her, no.
Okay, that's a weird way to answer that. What happened in that scenario then that she ended up with them that you all didn't have?
So our facility has 26 kennels, and on any given day, we'll get 2 to 3 calls per day about stray animals.
Mhm.
And we need someone to take these animals. So we ask the public to what we call a straycation or finder foster. So that person who found the animal will hold on to the animal for 2 to 3, sometimes 4 or 5 days until we either have space in the shelter to take the animal or the animal is reunited with its owner. In the case that you're speaking of, Miss Sipe found a dog. She called our facility. We told her we don't have space for that animal currently. We got a picture of it. We posted it on social media. We posted it on our page as a stray. She held on to it for a few days. It never came to our facility.
Straycations is
Straycation.
a very, very clever term.
Mhm. 65% of stray animals get reunited with their owners before they come to our facility.
That's a good statistic to know.
Yeah, it is.
What about a chicken? What you think a chicken costs a day?
I would say $20 to $30 a bag of food,
Per bag of food, which you don't give them a day, right?
maybe a week.
Okay.
We have an objection.
Object, but he's asking her to speculate on animals that she just advised that she doesn't have care for. She
Yeah.
said they only care for dogs and cats at their facility, so this is potentially outside of her personal knowledge, or she's asked to speculate on pricing.
Judge, we're talking to the director of animal control that runs a facility with many different types of animals who I think
You have
that's
many-
directly care.
You have many exotic birds that are in your animal shelter.
We only do domestic animals, dogs and cats, and the occasional guinea pig.
So have you ever had to provide food and care for birds of any kind?
No.
Appears that she would be speculating. Sustain the objection.
Okay. Well, let's talk about dogs then. What's a dog cost today?
So depending on medical care and how it is.
Just a regular
medically,
dog.
So a dog without a medical case,
Yeah, just a regular dog.
we typically charge $35 a day.
Oh my gosh. Okay. At any point in your director of animal control at any point, do you help anybody or homeowners or people like at all, or are y'all just pretty much into the grab and go game?
I'm confused by your question.
Do you ever take funds, like there's this fund that you had set aside? At any point, do you share that with the public if there's a particular living situation? Like, I guess, do you ever help people or do you just rescue the animals?
So we are set up for education,
Mhm.
for enforcement, and for community resources.
Did you provide any of those to the site?
No.
Okay. That's all, Judge.
Mr. Hudson, do you have any questions you want to ask? You want to be involved in questioning? I'll give you an opportunity.
Am I involved in questioning, Your Honor?
I don't know. The Court of Criminal Appeals and the Court of Civil Appeals probably couldn't answer the question either. But I'm not asking you to do it. I'm just asking you if you want to do it.
I think in this witness, I will personally rest and have no further questions, Your Honor.
All right. You need to redirect for Ms. Schultz? Thank you, ma'am. You may step down. You can now have a seat in the courtroom. Call your next witness.
My next witness will be Amy Haverstick.
You will step up, please, ma'am. Raise your right hand and be placed under oath.
Do you solemnly swear firm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Good afternoon, Ms. Haverstick. Can you please state and spell your name for the record?
Amy Haverstick, AMYHAVERSTICK.
Okay, thank you. And where are you employed?
At Animal Rescue Corps.
Okay, what is your role at Animal Rescue Corps?
I'm the Director of Operations.
Okay. And what are your duties there?
They are vast. I'm ultimately responsible for the shelter. I handle all the field operations, field team, our fleet, our purchasing, on and on.
And how many years have you worked at ARC?
I've been with ARC as an employee since 2015 and as a volunteer 3 years prior.
And do you have any training in animal welfare?
I do.
Okay. And how many years have you been involved as a whole in animal welfare?
Employed since 2011.
Any prior past experience in animal welfare?
Just volunteering.
And how many cases would you say you have been involved in?
With Animal Rescue Corps?
Yes.
At least 180.
Do you know approximately how many animals you've evaluated in the context of your animal welfare experience?
Over 10,000.
I'm sorry, how many?
Over 10,000.
And how many animals have you overseen the day-to-day boarding care for?
All of them since 2015.
Have you previously been qualified as an expert in court in the field of animal welfare?
I have.
Okay, approximately how many times?
3 or 4.
Okay. Have you ever been disqualified or has your testimony been excluded in court?
It has not.
Have you provided training to others in the area of animal welfare?
I have.
Are you experienced in caring for the type of animals involved in this case, specifically avian, dogs, horses, chickens, exotic birds, encompassing avians?
Yes, overall.
Are you familiar with the acceptable standards of cares for those types of animals?
I am.
Do you have any specific training or experience assessing conditions related to animal welfare as it relates to safety, environment, and other welfare considerations for the care of boarding animals?
Through work, through
Mhm.
my job. I've had national training as a cruelty investigator.
Do you have any specific trainings on performing ammonia level testing?
I do.
And were you working for ARC on August 7th, 2025?
I was.
Did you personally examine the animals at issue in this case while they were at the property of 2740 Mossley Ferry Road in Ashland City, Tennessee?
I oversaw the field operation and physically witnessed each animal, yes.
Okay. And are your evaluations and opinions you will give in this case based on your training, experience, and personal observations?
Yes.
Okay. And are your methods of opinion consistent with those generally accepted in your field?
They are.
Ms. Haverstick, I'm good. We were recording everything. This room is beautiful, but it has real tall ceilings. So we're going to ask you to speak up as loudly as you can. Okay.
Sorry.
Your Honor, at this time, the petitioner would like to tender Ms. Amy Haverstick as an expert in animal welfare and boarding care as it relates to these specific types of animals involved in this case.
I'm going to object to that, Judge, unless she's a vet. That's who I would like to hear from as far as the care and welfare of animals is a veterinarian.
Under the rules of evidence, a witness can be qualified as an expert by reason of education or training or experience. You can even you can have a plumber be considered to be an expert witness based on his years of experience and training. At this point, I found Ms. Haverstick to possess the necessary experience and training as well as the personal care for the types of animals that are involved, and the fact that she has been qualified as an expert in other courts in the state of Tennessee. So as a result of that, I overrule your objection and grant that she will be considered to be an expert.
Thank you, Your Honor. Did Cheatham County Animal Control ask for ARC's assistance in this case specifically?
Yes, they did.
And I'd like to show you the previously entered exhibit number 1. Which I believe I left on my desk.
I think that's what she tried to show me.
Do you recognize that document?
I do.
Okay, can you explain what it is?
It is the designee letter, or it's our agreement with Cheatham County Animal Control to assist with this. It is our letter from Cheatham County Animal Control designating us as their designee for this situation.
And is that a true and accurate copy of the request you received from Cheatham County?
Yes.
And it was your understanding that Cheatham County Animal Control was investigating and potentially would be seizing animals in a criminal case?
Yes.
And can we refer to Animal Rescue Corps as ARC?
Yes.
Okay. Did ARC agree to be Cheatham County Animal Control's designee?
We did.
Okay. And what is your understanding on why Cheatham County Animal Control needed your assistance?
We knew there were exotic birds involved, and 2 dogs and a horse. Cheatham County is not, and chickens. Cheatham County Animal Control is not set to support those.
And did ARC have any discussion as far as the financial arrangements between you being a designee with Cheatham County Animal Control? Were you going to charge them anything too?
No.
Okay. And what was your understanding of who would cover the cost of care?
We would cover it.
Okay. And what was your understanding as far as how you would be getting reimbursed for your cost?
Generally in the field, if we get a surrender from the owner, then there's, we go forward with that. Everything's still treated as evidence. So we get through that period. In this situation, there was not a surrender. And so as part of our agreement, we do point to 3914 210G that we will recover those costs via the bond.
And pursuant to that statute, were you aware that you could bring a petition to the court on your own behalf
Yes.
to request the bond be ordered?
Yes. So sorry.
Were you on scene at the time of the actual seizure of the animals?
I was.
Okay. And from whose custody were those animals seized from?
Becky Sipes.
Okay. And how many animals were seized?
17 total.
And how many animals did ARC agree to be the statutory designee for?
All 17.
So we're going to move into the condition of the animals at the time you received them in your care, of which I would like to discuss if there was any video taken on the day that that the animals were seized.
There was.
Okay. And who took this video?
It would have been either myself, Tim Woodward, our executive director, Kim Rezac, or Michael Cunningham.
And so it would have been ARC's
leadership.
Okay. And are these videos that you regularly and ordinarily film on any seizures you're involved in?
Yes, there are many videos and photographs of the entire scene.
Okay. And have you watched the video? Have you watched the video prior to your testimony today?
Yes.
Okay. And so there's a video on this flash drive that I prematurely took out to have set up, and it was in this plastic bag. Would you recognize this
Yes.
bag, and how do you recognize that?
I signed it.
Okay. Okay. And the video contained within this flash drive, does that fairly and accurately depict the environment and the living conditions of the animals that you obtained custody of at the time of seizure?
It does.
And that date was August 7th, 2025?
Correct.
Okay. And are the conditions of the property and the animals as depicted in this video going to be used to provide your assessment as far as the care needed once in your custody?
Yes.
And would reviewing this video now help during your testimony be helpful to you to explain your opinion further?
Sure.
Okay. Your Honor, I would like to play the video and subsequently move it into evidence as the next listed exhibit.
All right, how do you wish to play the video?
I have adjusted with the staff as far as arranging it on
Right.
my personal laptop. Okay.
Judge, at this point, I'm gonna object to the playing of this video. I mean, this is evidence in her criminal case. That they've already wrongfully put online and posted. Again, a discovery
Well, I'm not
issue.
going to show this evidence, this videotape on the live stream of this hearing to avoid it being disseminated among anyone who wants to watch here. But otherwise, this would be an opportunity for you to review the evidence and conduct some discovery on your own behalf if you wish to do so. But I don't think it's inappropriate or impermissible for them to play the video, because clearly they're asking for reimbursement of the cost of care for animals removed from your client. Part of that means they must show, in my opinion, a justification for that removal. And this video would be their evidence of doing that. So note your objection and I'll overrule it.
Yes. Thank you, Mr. Wilby. Sorry. So I would like to move the video into evidence if I
Right,
already
we'll
did
mark
not.
that as the next exhibit, is that too?
So did that video fairly and accurately depict the condition of the defendant's property and the animals that were seized on August 7th, 2025?
Yeah, somewhat, yes.
Sorry?
Yes, it depicts it. Yes.
And were you identified in that video?
I was.
Okay. And did you have any personal protection gear on?
Yes, anyone entering the house was required to wear a respirator with ammonia cartridges.
Okay. And why was that precaution taken?
Generally, as a rule, if you smell it before you go in the door, you know that it's going to be high enough to require protection, but we always go in with protection and then we take an ammonia reading from inside the house.
Could you smell ammonia from the exterior of the home?
You could from the porch.
And were any ammonia level testings completed?
Yes,
And who did that testing?
I did.
Okay.
Using
And-
Draeger tubes.
I'm sorry?
Using Draeger tubes.
Draeger tubes, okay. And what was the,
Draeger tubes is a type of testing system. It's just a glass tube.
and what were those test results?
Ammonia levels were 100 parts per million.
And in your expert opinion, as far as your training on ammonia testing, what does that number mean?
I mean, it's unsafe for humans and animals.
Animals, okay. What would be a safe level?
Less than 5.
Okay. And again, how many was this?
100.
And so you mentioned that the ammonia levels were unsafe for animals. Is that inclusive of avian species?
It includes avian species, yes, and dogs, cats.
Did you observe any of the animals inside the property or on the exterior of the property having any access to food or water?
Not to my knowledge.
Okay. And there was some footage shown of some.
There was some food, but it had maggots in it.
Okay.
So not clean, not potable water, not clean food.
Okay. But were the animals in access to that?
No, it was separate.
Okay. And did you find any property, any food on the property that was not contaminated?
I did not.
And did you find any uncontaminated water on the property?
No,
Did you notice if there was any running water inside the home?
I don't believe there was.
And from information we'll get to, is fresh fruits part of the exotic birds' diets?
Fruits and vegetables.
Fruits and
yes.
vegetables, okay.
Nuts.
Did you find any fresh food in good condition?
I did not.
Regarding the room that we witnessed on the video with the cage birds, what were the sanitary conditions of their cages?
They were very filthy. Definitely needed cleaning. There was feces and just that general grease on the entire cages, all the cages. Refuge on the floors.
Mhm. Okay. And again, just to confirm, was there any food or water inside the cages?
Not that I saw.
And did the cages have everything that a bird would need if confined?
Not in my opinion, no. They did lacking enrichment. They were lacking variations. They did have perches, but they were very soiled perches. Exotic birds need a lot more than that to thrive and survive.
And what was the overall condition of that room that the avians were confined to?
It's not good. There was trash thrown. The whole house was very full of, I don't want to call it all trash, but you could hardly walk through the house. The avian room was probably the more clear passage wise, but it was very, very unkempt.
So from, again, reviewing the video, we saw some animals. Was there any birds that were outside of cages?
Yes, there were
in the home.
In the main bird room, there were two that seemed to go in and out of the cage. In the master or the primary bedroom, there was a macaw that was loose, and also an umbrella cockatoo that was loose, and a wild starling that was flying around the bathroom.
Were there any other home animals inside the actual home other than birds?
Not that we could locate. There was evidence of being cats, but we weren't able to find.
Okay. And the video transferred to outside. What were the animals that were located on the exterior of the home?
There were 2 dogs, 1 mini horse, and 3 chickens.
And did you observe any food or water within access to them?
I did not.
Did you find any deceased animals on the property?
We did.
Okay. Can you explain what you found in that regard?
There was a chest freezer outside the main entry door. And in that, where the freezer was unable to close, there were a deceased rooster, deceased cockatiels, a baby bird of some sort. There was a couple of skulls that were around there that appeared to be avian as well.
So again, to recap, how many living animals did you observe on the property?
17.
And in your opinion, what were the conditions they were living in as far as relating to animal welfare?
They were not good conditions. The dogs were observed outside. They had missing hair. They had fleas. There's a little bit of rainwater that seemed to have collected in a small little divot. That was the only water that we saw. The birds were missing a lot of feathers. Beaks were overgrown. Nails were overgrown. The air was not breathable. The chickens, the the coop that was there was very unkempt. There was refuse in there. It was hazardous. There was no food in the chicken coop. One of the chickens was in and out of the coop, so they seemed to be able to get out of that. But it was very desolate, very unhealthy.
And the horse, as far as the conditions regarding animal welfare?
There was, I did not see any food for him, or there was some straw that was kind of laid over the ground, but that seemed to more as mud control by a camper that was in front of the house. I did not find anything for the horse. He needed a hoof trim pretty badly.
All right, I have another document. Sorry. Do you recognize this document?
I do.
And what is it?
It is our master intake.
I'm gonna object to this. I don't know. What this is.
I'm sorry, what did you say it was?
It is our master intake that lists all the animals removed from the property.
All right. And your objection is to what, Mr. Vaughn?
Same, same discovery issue that I have no idea what any of this is.
Well, for the purposes of this quasi-civil hearing, I'm going to overrule the objection and allow it to be put on. We'll give you an opportunity to readdress that at a later date, but right now, I would just like to get through the hearing. So overrule the objection.
Thank you. Who created, sorry, can you state again what this is?
It is our master intake list.
Okay. And who created it?
I did.
Okay. And what is on it specifically?
It lists which animals were removed from the property. The area section designates where they came from off the property. That pegs back to a property map. The intake number is the order in which we remove the animals from the property. Names, sometimes we have names that are given to us, sometimes we don't. Everybody that comes in gets a name. Then we have the species, breed, color markings, age, sex, and weight. Sex, age, and weight.
And is this a true and accurate representation of the animals that ARC took custody of as a designee on August 7th, 2025?
It is.
Okay. I would like to move this into the next exhibit.
Three.
Okay, I have another document for you. Ms. Haverstick, do you recognize this document?
I do.
And can you please state what it is?
It is a worksheet for the cost of care for the seized animals.
Okay. And who created it?
I did.
Is this a record you generally keep and create in the course of your regular business as it relates to being a designee?
Yes.
And was this record made at or near the time of the events they document?
Yes.
Okay. And are these costs based off of information you have access to in your regular course of business?
They are.
And is this a true and accurate representation of the cost of care ARC has incurred or will incur in the future for these seized animals?
It is.
Okay. I'd like to go ahead and admit this into evidence, although I'm still going to need her to continue to review it.
All right, we'll mark it as exhibit 4.
4. Okay, thank you. Okay. So were the animals inspected at the defendant's property? Were they examined by a licensed veterinarian?
They were.
Okay. And did the animals need medical care upon their seizure?
Yes.
Okay. And did the vet on scene advise of the care needed for these animals?
She did.
And did you incur costs for those medical services and treatment the vet advised?
We did.
All right, so we're just going to focus on the section reference medical services for now.
Okay.
What time frame do these costs cover?
They cover the day of seizure and a few days after.
And then the last line, the continuing vet oversight.
Yes.
Can you explain that, please?
We have ARC employs a veterinarian that comes to the shelter and provides oversight. She does a lot of veterinary exams. She's not necessarily the one that goes in the field with us all the time, but she is there every week to examine animals. And so we've allotted 2 hours of her time per week to observe, make sure everything is going well with the animals we have.
Okay. And do you?
These specific animals.
Yes. Does ARC pay that veterinarian?
We do.
And what is your anticipated monthly cost for that continued vet care for these animals?
It is $200 a month, correct? Yes. It's it's $100 a week, so $400 a month.
Okay. Okay. So related to the remaining medical services on this list, can you briefly describe what some of them are?
We've got heartworm and intestinal parasite control for the dogs, the 2 dogs. We did fecals on the dogs, heartworm test, which one of them turned up to have Ehrlichia, which is a tick-borne disease, treatment for that. All of the birds had to have testing done on scene and sent to IDEX to make sure that they were free of diseases. We also had to do, the dogs had ear infections, parasite infections. The birds were, believe all of them, everyone except the starling received nail and beak trims.
Okay.
And medicated baths for the skin issues that the dogs had.
Okay. And so as it relates to the cost associated outside of the veterinary care that we did discuss, the costs that are associated, how were those calculated?
The ones we were just discussing, the medical?
Yes, the
Okay.
medical.
They are from actual.
I'm gonna object to hearsay within hearsay. We're talking about, if we're gonna talk about costs and what the vet said, the care the vet gave, I'd like to speak to a vet about this. But we're talking about, just because this piece of paper says a judge, is not gonna be good enough for me to justify that this is what happened, or that this is even real.
The objection is that this testimony is based on hearsay. Your response?
That if I can lay the foundation, I will show that these costs are actually part of business records that are incurred in their ordinary course of business.
Well, those costs are not, the objection is as to what she's testifying to for, based on this record, is that correct? What the document is?
Yes, correct.
Those business records exception would apply if in fact this document you're referring to is a part of the business records, but I don't think that's been yet established. So I would sustain the objection until you establish a foundation under the business records exception.
Sure. Okay. Thank you. Are the costs associated with the medical services on this worksheet actual incurred costs by ARC?
They are.
Okay. And do these costs come from any records that you keep in your ordinary course of business?
They do.
Okay, can you explain what those are?
Via Patterson Veterinary Supplies. I do the purchasing for that. Chewy, through Amazon. I am responsible for most of those purchases.
Okay. And so those would be invoices and receipts?
Correct.
Correct, okay. And those are generally kept in your ordinary course of business?
They are.
Okay. I would like to hand you another document. Do you recognize those papers?
I do.
Okay, can you please state what they are?
They are invoices from Patterson Vet Supply, as well as, is that Chewy? Who's that? Chewy. Quite a few things from Chewy, where we paid for the testing for the University of Georgia. I'm sorry, they went to the University of Georgia, not to IDEX. I misspoke. And shows the appropriate payments.
Okay.
Via American Express.
Okay. And were those the invoices and receipts that you used to create your cost of care worksheet as it relates to the medical services costs requested?
Yes, as far, yes.
Okay. Your Honor, I would like to introduce the medical invoices as the next exhibit.
The exhibit 5.
Judge, of course, I'm going to object to this. This is what I got at 5 o'clock yesterday. I would assume. The other is there's no way to tie this to any specific animal. And as far as all these diagnoses and stuff on the other worksheet, it's not necessarily the cost or the number, it's the reasonableness is that I have the issue with all this with, because I mean, I object to these being entered as this. I've never seen it before. It's hearsay within hearsay. A vet needs to produce these if we're gonna, I mean, a vet needs to produce the diagnoses on this. This I've never seen. And I have no idea how this can be tied to Ms. Sykes' relevance.
Court understands your frustration, Mr. Vaughn, with being forced to have a hearing in a case where you say you've not received all of the information, but this is a quasi-criminal, quasi-civil procedure that the court is required to do because of the length of time these animals have been removed. And for that reason, it was not my inclination to postpone this hearing, even to allow you to review these invoices. The invoices that I've been handed or testified to by this witness as being invoices for veterinarian treatment and expenses that have been actually incurred by the Animal Rescue Corps in the treatment of these specific animals. It is, in this court's opinion, not necessary that each expense be attributed to each of the 17 animals, but rather that it has been related to the care of these animals in question, and therefore the court overrules your objection and allows it to be introduced as an exhibit. So.
Thank you, Your Honor.
Or can I object and get a true and accurate copy? These have been redacted. What is that? What we're redacting animal stuff? What are we hiding?
Your Honor, the redactions are account numbers and personal financial information that is relative to ARC. And additionally, it also redacts anything that is not related to this case to limit any confusion.
There's certainly a rule of completeness issue here, I think. I know you're getting frustrated with me, Judge, but I just don't like any of this.
Well, examining these records, it does not appear that there is anything that would render these records to be suspects simply because there's been redactions. I think that the elimination, we routinely do that in civil cases where there's personal information that's not pertinent to the issue before the court on a divorce case, such as social security numbers and so forth, would be redacted. In this particular case, I don't see, I suppose it could go to the issue of the weight to be assigned to these records if there is some indication that the information redacted was in fact relevant to the issues before us. But for example, the check that's written has a banking routing number that was omitted and redacted. That's standard operating procedure usually. And account numbers, invoice statements, and so forth. I'm going to allow them in over your objection simply because of the fact that the court is trying to determine the amount of a bond to be assigned for the animals in question. And although it does not have to be a dollar for dollar relation to the amount of the bond, it does have to indicate that there were expenses. So I understand your objection, and in the criminal case, you may have a valid argument to make regarding the discovery issues. In this portion of the case, it is the court's opinion that the records introduced are sufficient to relate to the issues before the court. So overrule your objection.
Thank you.
Thank you. Ms. Haverstick, can you explain a little bit about your ordering as it relates to, take an example as far as rabies vaccinations?
Well, rabies would be ordered in quantities of 50. That's how they come.
Okay.
There were not 50 dogs on this property.
Okay. And so is it fair to say you have a overstock that you can pull from when
Yes.
needed?
We keep vaccinations stocked at all times.
Okay. And so just to confirm, those invoices and receipts were to purchase the items listed here on the medical services rendered?
Yes.
Okay, thank you. Okay, so you referenced that you have continued veterinary oversight on these animals and that they are paid staff. Is that accurate?
That's correct.
Okay. And how much do you pay your vets per hour?
She makes $85 per hour.
Okay. And how much are you requesting on your cost of care worksheet?
$50 per hour.
$50 per hour. Okay. And do you expect any additional cost of care related to medical services here regarding these animals that is not reflected on your cost of care worksheet?
That is unknown.
Okay, why is that?
Anything can happen and we'll provide the care. I can't state absolutely not,
Sure.
They're living, breathing, sentient beings.
All right, so now we're going to shift to the boarding cost. How many days has ARC been the legal custodian of the defendant's animals?
It has been 237 days.
Okay. And are you requesting you be reimbursed for boarding costs to care for those
Yes.
animals during that period of time? Okay. All right, so we're first going to start we're focusing on the paragraph regarding boarding. We're going to start with the birds. How much are you requesting for daily boarding fees for the exotic birds?
$25 per day per bird.
Per bird, okay. And what is included in that $25 per day cost?
Food, enrichment, overhead, employees.
Okay, can you explain your overhead a little bit more, please?
Utilities, we've got to portion off, everything. It costs us about $80,000 a month, I believe. And we're using about 16% of our current space on these animals. So a portion of that has to be covered by the boarding.
Okay, thank you. So the food for the birds specifically, can you give me a rough figure of the amount of money you're spending to cover the food for the birds?
One 35-pound bag of 135-pound bag of food for the birds cost $150, and we go through about 1.5, 2 of those a month, and that's just the hard food.
Okay. What other food do they eat?
They also get nuts and seeds, and they get fresh fruits and vegetables every day.
Okay. So what would you estimate as far as your total food cost for the birds only?
For a month?
Yes, a month.
Probably between $400 and $500 a month.
And what other expenses do you have for the birds?
We have the nails and beak trims. I believe we've done those 3 times since we've had them in custody. We also have the day-to-day care for them because the birds are exotic and they are not your everyday dogs and cats. Only staff members are allowed to care for them. So it's pulling people from that.
Okay. Is enrichment included in that daily cost?
It is.
Okay. Can you please explain what enrichment is?
Enrichment is these birds, they need something to do. So we buy bird toys from Amazon. We also make some in-house when we have the appropriate, items to do so. Birds need something to chew on, to make noise with, to keep themselves active, puzzles, find the nut, keeps them active and their brains working instead of just sitting there and falling into ill health. Birds need to be busy. So we spend a lot of money on.
Okay.
They're not cheap.
Okay. So can you give an example to the court as far as what an item looks like as far as enrichment and how the bird would use it and how long it would last that bird?
And it's sort of specific now that we've had them for so long, what bird likes. Some of them are, put together blocks of wood that they tear up and destroy, work their beaks on. Some of them are paper balls that they like to tear apart. We also use like Amazon packaging paper that comes in packages. They love that. They could be musical or noise makers. There's a big variety. Sometimes it's a cereal box with some paper and a nut in there with some twine. I mean, you can do some of those things, but different birds have different toys. Like a macaw needs a different enrichment than the Alexandrine. So it's different, but they're not cheap.
And how fast on average would they go through those?
And again, that's kind of bird dependent, but it's generally, they don't last more. Some birds that they last about a day or two, other birds, they could have them for a week to 2 weeks. But it's a constant replenishment.
And on average, how much would you say that you're spending a month on enrichment?
$500 to $700.
Thank you. Do you recognize those documents?
Yes,
Okay, can you please explain what they are?
they are copies of invoices, receipts for enrichment and food for the birds.
Okay. And so to clarify that those are expenses that ARC has incurred as far as providing the proper enrichment to the birds.
Correct.
And are those records kept in your ordinary course of business?
They are.
And were those prices used to help address your daily boarding costs?
They were.
And are those receipts a fair, true and accurate representation of the costs incurred?
They are.
Okay, I would like to enter the enrichment package as the next exhibit, please.
Obviously, I'm gonna object, Judge, but I know how it's gonna.
I want you to do on the record whatever you feel like you need to do. Don't worry about if you repeat yourself, just make your objection and I'll rule it.
Okay, Judge, I'd like to object to these random Amazon orders that who knows what birds these are topped. I don't know.
Again, the same ruling will be that this witness has testified these were expenses that were incurred on behalf of the animals that were removed, and the court allows the testimony over your objection.
Thank you. Is ARC currently, or has ARC since August 7th taken in any other exotic birds in their care?
We have not.
Thank you. Okay, so we are next going to shift to the dogs' daily boarding expenses. How much are the daily fees for the dogs?
$25 per day.
Okay, can you please explain how that was calculated?
Much the same way, using the breakdown of the amount of space that these animals are taking up and the amount of employees, food, volunteers that go into that.
And the food was part of this. How much are you anticipating? How much do you estimate you're spending in food for the dogs?
For the two dogs, they probably, between the two of them, go through a bag of food and maybe a case of wet food a month.
And how much is that roughly a month?
I'm sorry, as a month, per month. $30 for a bag of dog food, and I believe a case of wet food is about $25.
So
$55 in food.
And what type of daily care is being provided to the dogs as far as staff's requirements?
They are, of course, fed and watered, and their space is cleaned every day. They go on multiple walks outside. They have improved health-wise, so they are enjoying everything a lot more. They get enrichment in the afternoon, either via Kongs or a special toy. They are played with and walked and taken care of.
All right, we are now going to shift to the boarding expenses for the equine, which is the horse. How much per day is that?
We have $25 per, no, wait. Yes, $25 per day.
Okay. Where is the horse located at?
The horse is with one of our partners, Piccolo Farms.
Okay, and why is the horse there?
Because they are more appropriate to take care of a horse.
And again, just recapping, the agreement you made with Cheatham County Animal Control allowed ARC to make these arrangements
Yes,
if needed.
but they are all under our control.
Okay. So that is my next question. So who's deemed the legal custodian then of animals that are at your partners?
Animal Rescue Corps.
And so how were those boarding costs calculated for the horse?
Again, using the, overhead, food needs, and care such as farrier and that type of thing.
And is the $25 a day rate fair and reasonable based on charges in the area?
It is.
And have you provided payment directly to Piccolo Farms for the horse specifically?
Not as yet.
Okay, can you please explain why?
Well, we are waiting for this cost of care bond or via, no longer having to do that.
So was that a
And
discussion?
that was their agreement. That was our agreement with Piccolo Farms.
Okay, that they would wait until you recovered
Yes.
money from the bond to be
Correct.
reimbursed. Okay. Where are the chickens?
They are also, two of them were with Piccolo Farms.
And the third?
Is with another Art Foster.
And again, the agreement with Cheatham County Animal Control allowed you to place animals at
Correct.
partners. And who's the legal custodian of the
Animal
chickens?
Rescue Corps.
Okay. And how much per day are you requesting for the chickens boarding?
$5 per day.
And what's included in that cost?
Same as the others.
And what type of daily care is being provided to the chickens?
Food, water, fresh water, housing, clean housing, space to roam.
And is the $5 a day per chicken fair and reasonable based on the rate in the area?
Yes, it is.
Okay, and have you paid for the boarding charges for the chickens?
With Piccolo Farms, no.
And again, is that based on your original agreement?
Original agreement with Piccolo
Wait.
Farms, yes.
Thank you. Okay, so let's recap. How much for the 237 days that you've boarded these 17 animals based on the daily rates that we've discussed in detail? How much has ARC incurred for the boarding expenses alone?
$86,505.
Okay. And I want to clarify, that's ARC and their partners have incurred.
Correct. That's for all the animals.
Okay, thank you. And what is the amount of medical expenses that has been incurred to date?
It is $5,383 for all the animals.
Okay, thank you. And what is the total expenses combining the boarding and the medical services that has been incurred from August 7th until March 31st as of today regarding the boarding and care of these animals?
$91,888.
Okay, thank you. So we have at the bottom of the page anticipated costs for the next 30 days. Is that accurate?
It is.
Okay. And can you explain the total combination for the 30 days?
It is the amount to board all the animals per day. It's $365 per day for all 17 animals. And times 30 days is $10,950. And to cover the veterinary oversight for 1 month is $400 for a total of $11,350 for a 30-day period.
Okay, thank you. So you referenced just a little bit ago that as director of operations, that what was your monthly operating budget for your facility?
$80,000.
$80,000. And how much space in your facility is the defendant's animals taking up?
Approximately 16%.
16%. Okay. So doing the math, 16% of $80,000, my math notes show that's $12,800. Does that sound correct?
Correct.
Okay. So that is $12,800 of actual operating expenses based on the amount of space and need that the defendant's animals are taking up for just the birds and the dogs. Is that
Just
correct?
the birds and the dogs, yes.
Okay. And what, so what would be the additional expenses in addition to that? the boarding cost for the,
Objection leading.
Sustained, leave it with us.
thank you.
So this 16% is for the birds and the 2 dogs
Yes.
of our facility. There are additional animals. This boarding covers all 17 animals.
Okay. So just alone, looking at your overhead cost for birds and dogs is $12,800, but how much are you asking for all 17 per month?
$11,350.
So based on that, you were giving the defendant a discount based on your overall operating expenses.
Correct.
Do you have additional overhead expenses that are not included in this cost of care bond request? Do you have additional expenses we haven't requested?
Not to my knowledge.
Do you have any expenses that you have not provided any receipts for?
Fruits and vegetables, that sort of goes in with our normal weekly grocery runs for the shelter.
And have you needed to purchase any other supplies that are not included on this list?
We bought some caging for the birds.
Have you needed to pay any staff any overtime?
No.
Have you taken on any other rescues since August 7th, 2025?
We have,
Do you recall how many cases you've done?
I believe it's 16.
And has the space that you are using to board the defendant's animals, have they limited your ability to provide care for any of these other rescues?
They've taken up the space that we would normally use for puppies and newborns and moms, which is more of an isolated space. So we've had to create other areas for that.
Have you had to incur any additional expenses by limitation of that space?
We've had some boarding fees ourselves for a case that we did.
Do you recall how much in boarding you spent for that case?
I believe it was just over $3,000.
What type of entity is ARC?
We are a nonprofit.
And do you do fundraising as part of your organization?
We do.
Okay. And do you know how much, do you know if the fundraising you potentially have received from this case, from your donors, has that surpassed any of your expenses that are not included on this cost of care?
It is not. Wait, say it again.
Sure. So
I got lost.
if you have received any fundraising for this case specifically from your donors,
That has not exceeded
it has not
the
exceeded.
expenses, no.
Okay. And to clarify, the expenses not included in this cost of care that you covered, the
Correct.
additional boarding and the caging and.
Correct.
Okay. Have you been a designee in a criminal cruelty matter before?
Many times.
And what was the longest length of time you had custody of those animals?
409 days.
And did you receive a security bond order in that matter?
We did.
And has ARC been reimbursed by Cheatham County Animal Control for any of the expenses incurred today?
We have not.
Has Ms. Sipe reimbursed you for any of the expenses incurred today?
She has not.
Should Ms. Sipe fail to pay the bond per the statutory guideline or agree to surrender these animals, what would be ARC's next step?
Once they were no longer part of the evidence for the case and we had ownership, they would then go to our plate, through our plate pays. Sorry. very dry mouth, they would go to our placement partners.
And would ARC be receiving any money from those placement partners?
No,
And if those animals are adopted later, would ARC receive any money from the adoption fees?
we would not.
Has ARC made any money off of this case?
We have not.
Will ARC make any money off of this case if they were to receive ownership?
We would not.
And if ARC is not granted an order or the bond is waived for the defendant for whatever reason, and ARC does not get compensation on this, how would that affect ARC?
We would continue caring for the animals.
And how would that affect?
Repeat that.
I said, we will continue caring for the animals. That's what we do.
And how would that affect ARC financially?
It could limit some of the cases we would be able to do.
And how would that affect your relationship with Cheatham County Animal Control?
It would be hard to justify.
So one last recap. The cost of care on this worksheet is provided the support you've provided, it's fair and reasonable based on the cost associated.
It is.
Okay, I have no further questions at this time.
We're going to take a recess.
I don't know any that are.
All right, Mr. Vaughn, you have questions?
Yes, Judge, I do. Lots. Some I can ask, some I can't.
Okay, good afternoon, ma'am. My name is Winston.
Hi.
I represent this site. Okay, so how much money does ARC make a year? What's the tax return? Do you have a tax return?
I have one,
Okay.
What was the question again?
If she had a tax return from ARC,
The tax return from ARC
yeah, like
for ARC?
for ARC,
Okay.
but we can't find that one. What do you think a tax return would look like?
I don't do the tax return.
Okay,
I'm the director of operations.
so you're, all right, explain to me the hierarchy here. Where,
So an executive director,
okay,
we have a board of directors above that. We have an executive director, and then under the executive director is myself, director of operations. We have a director of animal welfare and placement. We have a director of administration.
okay. Are these all salaried positions?
Yes.
Okay. The people that work, where, all right, so is ARC just in Gallatin, or is it all over and there's like, almost like sects in every,
There's almost like what?
like sects, SECTS,
Like,
pockets all over the country of
no.
use? Okay,
We only have about, I believe it's, I can't remember exactly, 8 or 9 employees. And we utilize a lot of volunteers.
okay. So most everything is done, would you say most everything's volunteers?
No,
Okay. The day-to-day stuff is,
but we have a shelter manager, we have an animal care person, and then volunteers come in to assist.
okay. And so those are not paid in any way.
Correct.
Okay.
They get lunch.
Lunch?
Mhm.
Fair. Seems reasonable. So who would know we're on about in your line? Would the executive director be?
Executive director.
I mean, are we talking about, would you think that is ARC operating at a loss?
I mean, I stated that our monthly expenses were about $80,000.
80,000?
Mm-hmm.
How big is this place?
What do you mean? It has to do more with the animals that come in. How many animals do we have?
How many animals
What
do you have?
it varies by day. I could have anywhere from 20 to 350. It depends on the case that we've done, what animals have come in, what animals have gone out. It's a very fluid situation.
Who would know how much money ARC has made since the release of this video?
Not myself.
Okay, that's fair. Do you often do the video thing?
We do.
Okay, even when an ongoing
We
criminal.
run 100% on private donations.
Okay,
Without raising money, we can't do cases. We can't help animals.
okay, so it's
It's a cycle.
it's donations.
It's donations and grant. We have a few grants, but I don't.
Okay. But just one of those things perhaps future watch out for is releasing evidence and ongoing investigation. I mean, that could be a bad thing.
Is there a question?
Huh?
Do you have a question?
Yeah.
What's your question?
Why do you think it's okay to release evidence
I do
on my
operations.
ongoing criminal investigation?
We don't name any names. That could be anybody's house, anybody, anywhere.
It's all over.
No, it's not.
Hold on, we have an objection.
It's being argumentative regarding the release of information regarding criminal charges.
Well, I just would like to know why she thinks it would be okay in an ongoing criminal investigation with a human on the other attached to it. That would be okay for the sake of them lining their pockets with money.
Number one, the objection is being argumentative, overrule the objection as to that part, but limit your questions to why she feels that it would be okay to put that online. She is not a member of the law enforcement community as far as this court is concerned. She is a private entity that deals with the care and rescue of animals. So I don't think the same rules would apply in a criminal case, but I'll allow you to ask if she has any instruction or any advice or education that would require her to avoid posting that information online.
Are you aware of the pitfalls for Ms. Sipes' due process rights by posting that
We never
online?
identified her. We never identified the address. Now, if someone comes in and identifies themselves, that's on them.
Okay.
We would never identify name, address. We would not.
Okay, so at some point in all of this, you were willing to waive the cost if Ms. Sipe just gave up her animals.
Mhm.
But because she won't do that, now it is about money. Is that correct?
I didn't write the statute,
Okay.
but if you're going to prohibit animals from moving on and out of our care, then if they're your animals, then you should cover the cost. That's the statement of the statute.
Has Ms. Sipe offered to help you all take care of the animals?
That is not an option. They are evidence.
Well,
and
like the evidence
we're-
you leaked on YouTube?
Oh, well, I didn't leak anything.
Right. So effectively, this document, did you prepare this?
I did.
Okay. Would you agree that reasonableness in the care of animals is subjective or objective?
In what way?
Like this to me looks like a pet spa day kind of price list. And the people asking the money are the people with the name your price tool. That's what I'm asking about.
Okay, the statute states fair and reasonable, and that is what that is. It is a reasonable amount. If you went to go board your exotic bird somewhere and have it cared for, it would be way outside of that. So the statute states that we have the right to recover.
So this stuff, do people donate this stuff?
No. I mean, do they sometimes? Sure. Any of that? No.
Okay. At one point I heard, did you say paper could be and what's the word y'all keep using for just playing and having fun? What do y'all?
The correct term is enrichment.
Enrichment. Got it. Paper is enrichment?
I said it can be.
Okay.
That it is used sometimes. It can't be, you can't just throw a bunch of paper in there and expect these birds to thrive. No.
Right. But some birds like the paper. Is that correct?
Sure.
Okay. You said $400 to $500 per bird per month is rent. Is that right?
That is not what I said.
What was no, that was for food, right?
For food.
And a bag of bird food costs,
$140.
okay. How many birds can eat off of that? Does each bird get their own bag of bird food?
No. We go through at least a bag to a bag and a half a month for the birds that are at the shelter.
For
which are only these birds.
So a bag and a half per bird a month.
No, that's not what I stated.
Okay.
It's a bag to a bag and a half per month for the entirety of the birds we have at the shelter.
And a bag costs $120.
And that's that costs $140. And that is just the exotic hard bird food. That doesn't include any of the other things we feed them.
Okay. Have you turned down donations in this case?
No,
For
what?
Anything, anything.
Not that I know of, but I don't handle all the donations.
Okay. Who does?
It would go through the website or through our director of development.
Okay. Is there, who's the accountant person? What is their name?
Well, it would go through Tim, through our ED.
Tim, what's his name?
Woodward.
Woodwork?
Woodward.
Woodward.
WOOD, WARD.
So he's the guy that sees the money?
I mean, it is a group effort here, but yeah, I mean, does he see? Everything is discussed with him, sure. But we have a director of development. We do have an accountant that we use. She's not an ARC employee.
Okay.
But, that is all dealt with through him.
When you went to go take these birds to the vet, you just use one specific vet? Is there a vet that comes and volunteers sometimes?
Yeah, we do not take them to the vet. There was a vet on scene that did the initial testing swabs and the initial assessments. And then that same vet came to the shelter and did further, deeper exams. And then we do have a vet that we employ that is there every week.
Do you ever help people?
We are in the animal protection.
Right, but when you come across homes, do you ever use the resources with which you all have to assist humans?
If it was possible, but this is a criminal case. I don't have access to that. I didn't seize the animals. Animal control sees the animals. We are there to assist. Now, do I have empathy?
Y'all are there for the video, so to film the video.
No, sir. We were there to assist these animals.
Who physically touched the birds and removed them?
We did.
Okay. So you did seize the animals.
We took custody of the animals.
Aha.
The seizure has to be called for, and we are not law enforcement.
Got it. Who came up with Operation Skyfall as the name?
I have no idea.
Um,
We name all our operations.
So what did you say per bird per month was the
It was what, 16% of 80,000?
Yeah.
I don't have the paper in front of me. It's like 12,000 something.
So a month, what does an individual bird cost?
A month, what does an individual bird cost? They cost 25 per day, but times 30 days.
Okay. I'll pass, Judge.
Redirect.
Regarding volunteers, who is taking care of Miss Sipes' animals at your facility?
Only ARC employees.
No further questions.
So no other person touches the Sipes animals, but ARC employees, not one volunteer has ever touched a bird taken care of.
I mean, touched a bird? And no, we don't do that.
Volunteers have never taken care of animals.
Not specifically, no. I mean, what do you mean by taking care of them? The daily care, the daily,
The enrichment bowl.
well, I mean, sure, somebody can put water in a bowl, but generally that area is for staff only.
Thank you, ma'am. You may step down. Ms. Schultz, I know you had said you may have another witness. We're about to quit for the day. And if you have other witnesses, we'll have to resume them on that date I've given you in April. Is that the case?
I do.
Based on our experience this afternoon, I don't think even one more witness would be a quick matter. So we will adjourn this hearing and come back on the 13th of April in Stewart County. If anyone that needs to appear by Zoom on that day, we'll give you the Zoom link once it's set up. And you can appear by Zoom. If you can appear in person, obviously I would prefer that. But Stewart County is where I will be that morning. And let me ask this question. What has everybody got on the 6th of April? That's Monday.
Monday, I'm free. I don't know. 6th of April.
6th of April.
7th through the Tuesday, Wednesday, Thursday, I've got a CLE conference. But I hope surely this won't take another whole day.
I'm sorry, what is it?
The next 3 days after the Monday that we're talking about, I will be at a conference, but surely this won't take an entire whole day.
We make no promises.
I do.
Well, the 6th is my circuit civil docket call in Stewart County, and that's typically not really long. So I can meet you all in the Dixon County Justice Center, which is halfway between Stewart and here, and we could conclude this case.
On the 6th?
On the 6th.
In Dixon?
Yeah.
Okay.
Are you available, Ms. Schultz? All right.
Can we make it like a 10 o'clock time?
Well, let's set for 11.
Okay.
I'm going to double check with the clerk. Obviously, the clerk's office is closed right now. But if we could do it at the 6th in Charlotte at 11 o'clock, that would be in courtroom 5, which is my normal courtroom. And we can resume with her witnesses. And then we can also, if you resolve this case by any sort of an agreement, then, we can take it up at that point.
Fair enough, Judge. Thank you.
And if we have to get this as far as the visitation portion, speaking with General Hodlin, the state's of the position that is, I know it's labeled visitation, but it's more of a modification of a bond condition. So I think at that point, since we're kind of in civil criminal limbo land, that we would take that part over.
Yes, let's do that.
All right. Then we'll adjourn for the day and come back together hopefully at 11 o'clock on the 6th day of April. Yes, not really, but yes. You asked the wrong question. It's like I used to tell my secretary at my office, and they would say, do you want to talk to so-and-so? I said, no, you asked the wrong question. Will I talk to so-and-so? Yes. You keep the hard drive and let me have the. Oh, man. You keep